We'll go to officially call this meeting back to order. Online, we have Commissioner Logan. Thank you for coming for day 2, and also have Darlene Fairchild, and then everybody else that was present here yesterday. So we'll go ahead and jump right in to pick up where we left off. We said yesterday that we'll start today. Fortunately, we have Brian Sledge here to make a presentation on our water disclosures. And we'll take that up first, since Brian was kind enough to attend. So Brian, if you'd like to come tee up, we have the.
Yeah, let me, if I can, and then I'll turn it over to Brian real quick. Just I want to make sure everyone knows what they have in front of them, because what we passed out yesterday, I took that. So you have a red line that has this. What you have in front of you, that red line, is this form right here. So because it's in Word, and I didn't want to retype everything, I took the prior version that we had, but all the language is the same. So this is the red line version that you have in front of you. And so Brian yesterday sent over changes to, and real quickly, you'll see that he is recommending in definitions, and he'll give you the reasons why here, striking the definition of water course, and then adding these 2 definitions dealing with surface water. And then just in terms of some of these are minor that he'll talk to you about. But then what the other is that the information that was previously said related to surface water and water courses, he struck now the information for the water courses, and is dealing, that section now deals only with the surface water rights that you might have. I think when you look at the clean copy and compare it to this copy, it actually, to me at least, and I think what Brian was trying to do was to make it easier for the seller to answer the questions, because a person who has surface water rights is probably going to have an adjudication number or filing number or some documentation that they either have in their possession or they don't have in their possession in that case. So I think that the changes that he has made in comparison to this form are really, really good. There's probably some tweaking that we need to do here and there, but we're that's what I think that we have. So you should have a clean copy of what is this, if you want to look at, if we're not looking at the strike throughs. And then the other form that's there is the paragraph in the contract form that triggers this form.
And if you want to look at the materials at what we had proposed at the last meeting, we're looking at page 116. That was handed out this morning. 116 is the original version. And then the motto, of course, the red lines is what Ron worked on late last night or early this morning to provide to us to be able to see real easily. So thank you, Ron.
Good, Brian.
Hey, you're up, Mr. Sledge.
Thanks for having me back. I want to thank the committee again.
That was kind of surprise starting. Okay.
I think it needs to be muted.
Okay. Sorry about that.
I told Ron I felt like as we were preparing to adopt these rules and changes at the last commission meeting, I felt like a football coach who had his team drive all the way down to the 2-yard line and then decided he didn't want to score. But some of the comments that we were getting back from the realtors, both formal and informal channel comments, I just decided that, and I started talking with some other surface water rights lawyers about it, that this bit on the water course was just going to be too big of a pain in the neck especially for the realtors and brokers out there trying to fill out these contracts. Because we know as water lawyers, there are many times where we can't make the call on whether something is a water course, and we have to ask for an answer from the TCQ, and that answer can sometimes take, I got one that I've been waiting on for 3 years from TCQ, a guy waiting to proceed with construction because he hadn't got that determination yet. So, and we were weighing, well, what's really the benefit for the problems that we're encountering in our practice on getting that? And is there an easier way to get to it, to what we need that'll solve most of the problems? And so that's what we did. So the biggest chunk of this, and I'll go through the water notice before we go through the disclosure paragraph, is abandoning this whole idea of having anybody determine what's the water course, and the beds and the banks may be slight, imperceptible, or absent, et cetera, and so forth. What we really want to know in these transactions, and where we get lots of legal problems that we have to clean up between buyers and sellers, is if there's an actual water right. And when we talk about a water right, we're talking about this, and I've defined it here: surface water right. It's a permit, a certified filing, or a certificate of adjudication. And those are three types of documents that have been issued by the state over the last 100 or so years. But collectively, we call these surface water rights. They're all administered by TCEQ. We want to know if there's one of these associated with the property. And I had originally structured it as associated with the property, but then I was talking with probably the top surface water lawyer in the state a couple of days ago, and he's like, really, but what between a seller and a buyer, what do we care? What we really care about is whether the seller has one, an ownership of one of these water rights or partial ownership of one of these water rights. And so basically all we ask for in this, once we sort through it all, is, do you have one of these? If so, give us the number for it, the names on it. If it's more than just you, seller, if you're a partial owner, who else has an ownership interest and what's their interest, and give us that. And then everybody in the transaction's on notice that this is something that has to be addressed and disposed of one way or the other, right? And then the second thing we got at is the other biggest legal problem we're encountering on the surface water side. And the groundwater language in here was all, I think, pretty much good to go. A couple of little tweaks, but surface water was the issue. The other big thing we encounter in the surface water world are illegal impoundments. Where people don't know, or between buyer was a domestic user or a livestock user. There's certain exemptions for the requirement to obtain a water right. If you have a pond or a lake that's less than 200 acre feet, which is big, a couple of hundred or Olympic-sized pools up to. You can do that if you're just a domestic or livestock owner, but we have people that'll come on and they'll start a winery or something, a commercial business. Well, then it becomes something that requires a permit from the TCEQ, and you can't be utilizing water for it, agricultural irrigation, things like this, like the farmer or rancher or homeowner in the country could earlier. And so we just get down to two questions on the surface water. Do you have one of these water rights? If so, identify it by name and number. And is there a pond or a lake on the ranch? And we thought about going into trying to find what a pond or a lake is. There's no good definitions out there in Texas law, and we thought the vernacular people know. Is there a pond or a lake on the property? If so, yes or no. And we just put the language in here without making it further complicated under 3B. Is there a pond or lake on the property? Yes, no. If yes, buyer should ensure that the pond or lake has an authorized surface water right if one is required by law. Like I said, there's some that are exemptions. We just want to flag the issue so that there's a discussion about it, along with the language down at the bottom that says, these water issues are complex. You should ask an attorney. That's it. I pulled the definition we had built into number 3 that's now stricken through for surface water rights. I just thought, why not pull that up here to the definition section? So we pulled that up in there and put a simple surface water right definition that's consistent with TCEQ's definition in Chapter 11 of the Water Code. Another thing I had not thought of when the rules were published by TREC and in our previous discussions were coastal issues, but we had some comments that came up. People like, what if I live on a canal on, Galveston Bay, and, how do I answer these questions? Does that apply? Is that like a stream or river? And it clearly does apply. And so in addition to this surface water rights definition, we put a definition of surface water, just like we have a definition of groundwater. Again, using the TCEQ's definition, it includes the bays, estuaries, and arms of the Gulf of Mexico. And I knew when I wrote Gulf of Mexico, just copying the state statute, that I would invite a fight by some on what we should call that body of water. And I actually did some legal research. There was a bill introduced by Briscoe Kane last session to change all the code references to from Gulf of Mexico to Gulf of America. The bill didn't pass. It died in House State Affairs. So I thought we'd just stick with the current statutory terminology until such time as the legislature changes it. But so that's it. Just got rid of the whole water course. Every question about a water course. Look, do you got a surface water permit? And identify it. Do you got a lake or pond on the property? If so, be aware that you may need a permit. And that's the whole thing. And I thought that would be a lot simpler way to approach what we had previously drafted as a pretty complex issue even for us. And then I changed, and then we can go through it all, but I changed on the disclosure paragraph that goes in all the different things. Changed the question, sellers not aware of a pond, or instead of a water course, not aware of a pond or lake or their property. If you don't got a pond or lake, you don't have to go over here and fill this out. Inserted the word certified filing. I called the head of TCEQ yesterday morning, the head of their water rights department. And I said, we had not previously included those words in here because there's been an effort for the last 70 years to get rid of all the certified filings and convert them over to certificates of adjudication, have them adjudicated by a court. I contacted Dr. Kathy Alexander at TCEQ. Do we still have any certified filings? Yeah, we have like 6 left in the state. But if you're looking at water rights definitions in TCEQ, they're still included. And I guess for those 6, we don't want to leave them out of the form. So that's why I stuck that word in there. The only other thing I think substantively, and this is, I'm not willing to fall on my sword over this, but we would prefer in our world in both sections on the water notice, this option for the seller just to say unknown or leave it blank. I just got a feeling, again, based on some of the comments we were getting when the proposed rules are out there from some realtors, I'm just going to write unknown on everything. And that's not going to do anybody any good. You either know or should or know whether you're pumping water on your property out of a river or a water well, or whether you have one. Or you should try to find out. But anyway, that's it. And I had Ron also, there's a couple of changes you didn't make, and maybe that was a conscious decision, but at 1:30 in the morning when you were typing, on this definition of water well, we have the note in the last sentence: a water well may be owned or operated by an individual, by individuals, groups, cooperatives, or associations, or other legal entities, frankly. I just didn't know how that helped. And if we're trying to shorten the form, we've gotten it down to 2 pages solid, front and back, with the changes we've made already.
Okay.
I think that was something that SJ had stuck in there.
It was it was done in this draft here that's in our material. So that's where that happened. So, but you're thinking, or other legal entities should be in there?
I would just strike the whole sentence. I mean, it can be owned by any person, any person under the statutory definition. A legal entity, a business, a trade association, a city, an individual. I don't know what that gets you, but if y'all think it gets you something,
It doesn't change.
I'm just trying to.
Doesn't change the definition.
I think it's explanatory to some in the transactions that we're in, that when you have the shared water well, what's in the definition, and to help people understand, just because it's not on my property, just because it's, on my property operated by somebody else, it's still, to me, for the average consumer that's going to struggle with this to begin with, it adds a little bit more to understand.
I think that's within. If you think so, I'm fine with it. I was just trying to. I don't think it hurts.
I think that was the reasoning behind it, to kind of help understand in that situation, because that's a common misunderstanding.
So, okay.
water well, see what you just said. So I know of a subdivision, right, that he's developing out and he's got 5 wells for the whole subdivision. So this form would have to be filled out.
Yeah, and we can step back. Let's step back for a minute, and then we'll get into, I think, go detail by detail. I want to state that if you haven't already, instructors have taken the legal update course or new one for 2026, 2027, which is mandatory for all license holders in the state of Texas. And it's just now starting to be taught to the license holders beyond the instructors. And it has an entire chapter on water rights. And so some of these concepts, one of the concerns we had is everybody's going to get this form and their eyes are going to roll in the back of their head and they're not going to know what to do because they don't understand the concepts. Fortunately, Abby and Vanessa and the team did a great job drafting the legal update materials to introduce all these concepts and all these definitions in this mandatory course. So they'll have a preview as license holders of these concepts. This form won't be the first time that they're hearing it because they'll have to take it eventually over the next course to be rolling out over the next 2 years. But so that will help out a lot in at least a basic understanding of what these terms mean. The changes that I see that Brian had made for this time, I really simplified the form from what we've already agreed to.
Absolutely.
And so I like a lot of changes. I think we can maybe tackle it going through by the form, just walking through and bringing up the issues as we go so we can stay kind of focused on the changes and tackle the issues that way. You know, I know you put the laboring or in this, if you wanted to lead the discussion on those changes point by point.
Sure.
And we just march through the form.
Question.
Sure.
Do these rights, are they ever subject to or can be leased versus sold?
Yes.
Because it's only addressing a sale. Does any reference to the property rights being leased
It's
need to
really,
be disclosed?
it's really just a notice that the water is there or not, to have the discussion about, are these, then you would have the subsequent discussion about, oh, are these leased? Are they still yours? What's going on? It's just making people aware.
Yeah, if you're buying my property and you assume, based on your basic knowledge of Texas law, that you have the right to put a water well on the property and all that, but I've leased it over to Tony and you don't have the right, you want to know that before you buy it.
And how am I going to know that?
Because you have to disclose it on this.
Where is that question?
That question is, number 2. F.
So,
Thank you.
so in other words, the seller has to be honest.
Beware and farm and ranch.
Okay, well, let's jump to make sure we can move today efficiently.
Okay.
Jump right in.
So in the definition sections, we discussed last time most of these definitions. So first of all, let me just see if anyone has any comments or concerns about the ones that were there before, which are groundwater district, or water well, since those we're just bringing those over.
I do not.
I don't.
Okay.
The only thing would be, following up on your co-chairman's suggestion, if we keep that last sentence in the note on water well, I would just scratch the or before associations, put comma or other entities.
Okay.
So it's not presumed to be an exclusive list.
Okay.
I like that suggestion.
I like that too.
Okay. So we'll make that change. I'm going to do this in hand first as I go through the form. And then, so then we have the two new definitions here. Surface water means water in lakes, rivers, creeks, streams, and in bays, estuaries, and arms of the Gulf of Mexico. Didn't know if we need to put legs. No, I'm just kidding.
In the water code here for everybody's benefit as we're going through, the surface water is really defined as state water in the water code. And so when you think about surface water, it's owned by the state for the benefit of all the citizens of the state of Texas. And so the regulations flow from there on how it can be used. There's some exemptions, like you just mentioned, household and or domestic and livestock use. Versus if you bring in a commercial use like a winery, you may not be able to just freely use it. And so that's why there's permits that are out there that can be transferred and sold to a certain degree with the property and go with the property itself. And so that's why a lot of this is being brought to light that way. But when you think about surface water, think about state water owned by the state.
And Brian mentioned this is reflective of the statutory definition that we have. So I'm fine with that. These definitions or this whole form will essentially impose upon brokers to be familiar with what's the surface water right and what's the groundwater right. So, or what's the difference between surface and groundwater, which hopefully most of them have some basic understanding or know where to go. AI is a good source for that now.
In the interest of full disclosure, I mean, the point you just made is spot on. We've struggled. Groundwater doesn't have this problem. Surface water struggles with how folks use the term surface water in the vernacular versus legal definitions, which is actually state water when we're talking about, and there's diffuse surface water, which runs through the grass when the rain hits your grass or pasture before it reaches a water course or percolates down into the ground and becomes groundwater. Too complicated. So we're using the vernacular term, surface water, with the definition for state water, which is the TCEQ terms. But TCEQ, in a lot of its regs and like stormwater permits and stuff like that, refers to state water or surface water also. But anyway, normal people think groundwater, surface water.
And we get into the detail there a little bit in the legal update materials as well. So they're all licensed holders will have at least a preview of even diffuse surface water. So that it goes into a little breaking that down and who owns and how diffuse surface water can be used differently, owned differently. So you can do rain harvesting systems with diffuse surface water and own it yourself. It's not state water yet. So it's a real good preview on that.
It's hard.
And then on the surface water rights definition, I really like what Brian did here because it limits it to the filing. And so you either have a document or you don't have a document in that case. So, and then in paragraph 2, there's really no changes in.
And just before you jump on, Ron, just for everybody's information, TCEQ has a water rights database, and every single surface water right in the state is online in that database, which is searchable by a lot of ways. Anyway, sorry to go.
That's all right, no problem. So I'll show here on the, what Brian is recommending here, as he talked before, is simply being able to say, seller may write unknown or leave blank if unknown. So I think we had prior conversation about whether to put that in the instruction or not. So I'm fine taking it out because the way the questions are worded, either you're aware or you're not aware. So by answering no, then you're just not aware, you don't know. So.
That's fine by me. I want them to try to fill it out,
Yep.
not just hit
Yeah.
the first block like lead painted and unknown.
Yeah.
Just turn it over.
Yeah, no, I'm not aware whether any portion, yeah, I mean, that makes sense.
Yeah.
They're sufficiently qualified there.
Yeah.
And then,
Can I mention one thing on that, though? You know, we've got it to the best of seller's knowledge and belief, which means they do have to do some due diligence, so. Because it's not their actual knowledge.
Good point.
let's see here.
And that's at the beginning of 2 in the intro.
Well, that's okay. Want to change that? That's a good point to say, complete if, just taking this.
So the beginning has to have qualifications or statements saying must be completed to sellers in belief.
They're just cutting that out. Shouldn't they be doing that anyways?
Well, what she's saying, it implies an obligation to go research as opposed to what you know.
Oh, I want them to go research. Y'all don't do any farm and ranch? I want them to help give a good notice. We want this to have some benefit, some use.
I'm not opposed to it. I just wanted to.
No, it's a
bring
good
it
point. No, I'm glad you brought it up, but yeah, I want them to have some.
So I'm going
energy
to the
go.
baseline law, right, of us creating forms to comply with what's required versus creating new duties. That line, sometimes we do with our contracts both ways. Right now, there's no duty to investigate or to disclose these things. We're creating a new disclosure requirement through the form. And if this is a pretty significant change if there's a lawsuit filed later of, I just didn't know versus I didn't go online and research. And in the vast majority of residential transactions, I think, of outside the farm ranch context, sellers aren't right now definitely researching it. So this would be a new thing that we're going to have to start doing. They're going to be looking at the agents of, you didn't tell me I had to go research this. I just didn't know. And so agents are going to be put in the middle, I think, of some fiduciary potential issues saying, you didn't tell me I had to go look at this. And they're going to say, well, it's not my job to tell you you have to go look at it. And so I just want to talk that out before we
No, I think that's
just go with
a good point, but do you think complete to the best of your, 2 points, do you think complete to the best of seller's knowledge and belief creates a duty to go research? I'm with Brian, that doesn't make you go.
Well, and that's I was just
research.
going to the comment of
It
fact.
does, because you have to put to actual knowledge to not have to go research it. Best of knowledge and belief means if you got a flyer or you have been told you're in the Edwards, you ought to know it. It is a difference. There is a different standard there.
Well, okay, I got you.
So if we use actual
Let's say that's
versus,
not in there.
Mhm.
Let's just say that that sentence not in there. Isn't most, and I wasn't ready for this argument, but when I litigate, I mean, that's sort of implied that you were supposed to do it to the best of your knowledge anyways, whether we say it or not, you were supposed to do it to the best of your knowledge. I mean, there's not like, oh, I didn't tell you about my, the flooding on the property because it just wasn't to the best of my knowledge, so I get an out. Like, you still got to do
Yeah.
it.
mean?
and it's almost like, why do we have that to begin with? We're saying, well, aware if you know or not, right? That to me is, well, if we take that out, right? If we just have
I think
aware.
it's synonymous. I don't know if it adds anything.
The use of the word and belief.
Which just uses this notice and disclosure of seller's knowledge.
That's where I was looking into.
So we just
Yeah.
skip, we just don't have belief.
Yeah, it's an unusual
Well, not
word
best
to
of either.
use in a transaction. And for belief, if my belief is wrong, what defense does that person have over my belief? Well, I thought that was it. I didn't research it. Why is and belief in there? Is that a legal terminology, knowledge and belief?
It is a phrase of art, best of knowledge and belief, but,
Yeah, what he's basically, Ron's right. What is that? We see that phrase constantly in law. I don't know that in any way he says a phrase of art. I don't know that belief substantively means anything different by the courts. It's just a term of art we've been using since the dawn of time. That you start in law school, like, oh, the best of my knowledge and belief. Is belief different than my knowledge?
It's, I think, unusual for real estate transactions, at least to us as practitioners. I don't think we see that. And so that's a new word. We need to be able to understand why it's there and what it means and what benefit or risk there could be.
That's
I
a
mean,
good
we
point.
can't give, that's a legal call, but now you've put us in that position to say, well, that's my belief.
Or maybe we go with what the disclosure language is.
That's what I was
It's at the
thinking.
top
Just kind of
already,
split the
but it's-
baby.
It's at the disclosure language is at the very top of this form. This notice is a disclosure of seller's knowledge
Oh,
about
okay.
groundwater and surface water. So do we even need that?
I think we take that,
take it out.
take it out. That's.
Where have you been all day? Way to go.
She saves the best for last.
Oh, she's like, I got
Hold on
you.
one second.
Yeah,
What, complete the best, take that
I'm
out?
just looking at, sorry, go back to one before we kind of get past the definitions, but I was
Yeah. What else
looking
did you
at
line up?
water course address,
We put it back
intermittent
in.
dry periods. And when you look at the way it's worded now on 3B, it just asks is there a pond or lake on the water or on the property? But I don't see anywhere in here that it addresses dry periods. And so in Texas, there might be a pond that's been dry for 5 years. Does that need to be addressed somewhere in the definitions? Because they may not know that they need to indicate anything about a dry stream or a dry pond. Or does that even need to be disclosed? Because it could be years before there's any water.
And I think as some additional things on, when we get to that section 2 on tanks, and a lot of people think about tanks, and is that a pond, is that a lake, and whether it's dry or not, maybe we can look at adding that. Is there, go ahead.
Is a cavity in the earth that was a pond that's completely dried up for a number of 5 years. Is it a pond without water? I don't think it is, right? It's got to have water to be a pond.
I'd call that a pond.
I call it one too. And I would expect you to tell me that there's 3 of them out there, even if they've only got puddle.
They're seasonal.
Oh, yeah, that's a favorite word.
Yeah,
And this is
they're
seasonal.
What did you say?
Wet weather.
Seasonal.
That's not in the.
It's seasonal or
It's
wet
about 1
weather.
month out of the year, they might have 2 inches.
Surface
of
water.
We do use that word.
Lakes.
Means lakes, rivers, creeks, streams. I don't know. It just seems to me is.
Well, that's out of the code
Surface
itself, I
water is still
believe.
water.
Yeah, surface water is the
Yeah,
water
so-
itself, not the nature of
But
it.
to me, I think it's inherent that you got to have water first.
So,
I mean, if you have a
Well-
swimming pool that's empty, can you say, I don't have a swimming pool?
so it's,
Same logic.
to me, the pond, we're doing, like, we took out the water course, obviously, which had some of this, but when we get to where we introduce pond later, maybe that's the place to state it. It's not in definition of surface, because surface water is out of the code. Surface water has.
I'm not suggesting changing it, and that we may be just going down a rabbit hole here for.
But I don't think we are, because when it comes to tanks and when it comes to that has been probably one of the top issues that everybody's brought up. Well, what about a tank? And a lot of people think about tanks. And if it's dry, I think it's a good one that I haven't heard, but that's a good thing I can see a lot of people bringing up as an issue.
Yeah.
But it may be best to look at that when we get to where the actual pond language is.
All right.
3B, where it's introduced, but that's a good point.
So-
We can circle back to definitions. If it
So-
doesn't fit in
We'll
there.
just settle 2.
We're going to strike the complete to the best of seller's knowledge and belief.
Yeah, I think it's encompassed, that's a good
On number
point
two
out,
and on
Kenny,
number
that that's up top. And we haven't had issues with that
And
before.
Ron, it's on number 2 and on number 3.
Okay. Like I have these right now. I can't change these right here, so I'm just marking them. So we'll do that in 2 and 3. And then,
I have a question on wells.
Okay.
It's happening.
all right, you want to bring up, go ahead, Wells. since-
Well, the question I have on wells, and this is for me to know, there are a lot of individual developers, not big developers, that are hitting the country, north of Austin, and they're putting in 4 or 5 wells for the development. Does that mean he would have to fill this out for every lot? Is that
And
correct?
would a resale home have to fill it out?
Right, that's what I'm asking,
The
because this
answer
is,
depends.
huh?
The answer is it
Like every good
depends,
real
and I think the
estate.
questions try to elicit that information. If he's putting in 4 or 5 wells and creating a public water system,
Right,
are they all tied together?
correct.
And it's a public water system, and maybe that public water system's XYZ water company, or maybe it's Williamson County Mud Districts number 1, 2, 3. They don't have to fill it out because over here on K, our seller's disclosure, they're not providing it because the property receives water only from the following municipality: Mud, Specialty Utility District, Large Black Operational Private Water Company. If he's putting in 4 or 5, so the answer would be no on that. If he's putting in 4 or 5 separate little systems, each one to supply part of a subdivision, trying to avoid becoming a public water system subject to TCQ. And there's a lot of folks that 15 connections is a public water system. There's a lot of developers trying to avoid becoming that. And maybe it's owned by the homeowners association, one of these wells. They'll create multiple homeowners associations within a development, one for each well. I've seen it. Or they saddle one poor soul with having the well on their lot. Sometimes they put the well on like a green space lot. In which case, yes, you would get triggered, but this is exactly what we're trying to get. What am I getting into here by buying this lot? we've got some informal arrangement where the 6 people who I don't know, who are going to buy these 6 homes around me, are all sharing our water supply together. Who's in charge of it? Who's gonna take care of it?
That's what I was
Where
asking.
would they, in the simplest terms, we don't know anything about water rights going to transaction, the agent doesn't, the consumer doesn't. It comes to this question in K3E, and the root sees water from municipality, a MUD, other district water supply, or private water supply company. What's the easiest place for them to go look to find that information out about the private water supply company, let's say, or the water supply corporation? How would they determine, coming in completely ignorant of all
Your
the,
monthly bill.
Your monthly bill, yeah.
Well, what you're saying though already, though, they're not supposed to go determine it. They don't have to go look it up.
yeah, if they're not
You
aware.
don't want them to.
But let's say if they're made aware through some document that they receive, right? They'll be aware, right? So when they get this in, I'm looking at my bill, I don't pay attention, I just pay the bill. What's it saying on the bill that this is a private water supply company? What's it saying that it's a water supply? Now, we know for MUDs and for the city water and stuff, but for those that don't.
An investor-owned utility, Monarch Utilities, Southwest Water, Aqua Texas. I mean, the answer for 99% of the private water companies in Texas is going to be easy. It's, all these subdivisions down here between Butte or Aqua Water Systems. Which are not much different than the water supply corporations. Aqua Water Supply Corporation from Bastrop to LaGrange, Creedmoor Maha down in the southeast portion of the city.
I think what he's asking is it going to be on the bill so they know like where this is, or they're going to.
If I just hear your name, XYZ Water Supply Company, I'm not, is that really a private water supply company? Is that really a water supply corporation? I'm paying a bill to somebody.
If you're
I'm
paying
just
a
trying to
bill
see
to
how
somebody, that's usually I think that is the primary sign. If I get a bill for water from the city of Austin's my water supply. I think the bill is the answer to your question.
Okay, so and that's where the technical ones go in. I think the obvious thing is, okay, I'm paying somebody. But if people are really reading, trying to understand, that's where it can get.
Well, I think most of them are going to be obvious because most of them are going to be MUDs, WSCs, munis, or private water system. I think you're going to have that, or corporation. So I think there's going to be probably a few that have some odd names where they may raise the question.
And that's just, we're not dealing with a lot of them. I don't know how they're named. That's where I would raise the question.
The ones that we're trying to sniff out by, again, E will clearly exempt 99% of the properties in the state. And I bet it's more than 99%. The ones we're trying to sniff out that are all the problems are the other 1%. I don't know, old grandpa farmer Bob put the water well in and sold off 6 lots over the last century. Everybody's been getting water from that water well on his property. Now the grandkid buys in, says, I'm not providing water to anybody anymore. You've all bought these lots. They're not big enough to get your own water well. You're nowhere near a water supplier. You're screwed. And so that is what we're trying to sniff out specifically.
Yeah.
And I agree the payments in general are going to dictate, just the technical person trying to say, does it fit within here?
Well, if it's like that situation, if they did it correctly, when you get your title commitment, there should be easements to the water well with profit, the right to withdraw the water, and that should be disclosed on the title commitment. And if it's not, and you're getting water for somebody else, you may not have the right to continue to get water from them.
Right.
Should be, but oftentimes are not. I mean, when you have these types of situations, which are usually, in more rural communities or in very poor edges of urban communities that are outside of city limits, nobody bothered to get easements. I sold to my kid in 1950. He asked if he could put a pipe across the property line after I carved off this acre lot for him onto my property. 2 separate owners now. The person that came in, like most people, they turned on the water faucet and worked till they assumed it would be good.
And it does happen.
They moved there from the city.
And it does happen even in the city. I've got it here in, close to downtown Austin with wells, shared wells, some just for landscaping purposes, others for full use.
Yeah,
And
forgot about those.
So it's, I see the exact issue we're trying to sniff out, and it's one of the big reasons we have the forum. I'm just trying to think about, to Mary's question there, and somebody in that situation, or you're trying to look at it as a broker, what does that actually mean?
Right, because I mean, I asked, where's the water coming out? Oh, he put in 5 wells for the whole development. I'm like, okay,
Yeah, so
what does
there's
that
not-
mean?
yeah, exactly.
Thank you for that, those questions, because I think this conversation has been valuable for the brokers.
Okay, so I'm okay with, have it concern the bills, have that and paying. I was going to talk that through. So
Good. All right. So back to the disclosure form. We've made that, we'll be making that strike about knowledge and belief. And then, Brian, you stuck in owners and operators here, I think in item number 2 on page C2.
Well, we had the question, following wells are owned and operated, that could be separate, so we changed that to or. By the person identified, benefit the beneficiary. We had a line for the beneficiary, but the owner or operator and the beneficiary may be 2 separate people, so.
Okay.
We called for the information, but we didn't put a blank for them to fill the information in.
Okay. So I guess I think because we got sidetracked, we were walking through the form. So maybe if we back up just a minute. So number 2 there is going to be asking a series of questions related to groundwater and water wells. And so the first one is just, are you aware of any property that's located in a groundwater district? You're probably paying taxes if you are on that.
Okay, so I hate to open a can of worms here.
Well, then don't. No.
But the whole-
I'm with Ron. Remember, we can't make this perfect.
Okay, it's this one particular question on 2A that gets me. And it goes to this whole discussion of based on seller's knowledge and belief. If I answer this question, I know what's implied, and so maybe we don't open it, but am I aware whether the property is located in a district? Yeah, I'm aware. I'm aware that it's not. Or if I check no, if I just check no, I'm not aware, and it is, what has the buyer just inherited? If it in fact is in the Barton Springs Edwards Aquifer Conservation District, and the buyer said, no, he wasn't aware.
The form's useless.
Well, yeah, I would just assume as buyer that answer meant, no, I'm not in one.
Well, the one problem we have on that question in particular, the statutory language in 500 of the property code has the exact same question, and it's based upon being aware or not aware. And so we have one statutory standard that's already having to be filled out by everybody. And if we did something different here, it would be the
aware
same,
language
but
is in the statute?
It is.
Well.
I mean, are you saying it should say if you are aware, which one? I mean, are you trying to figure out that?
Or just say, is the property located in?
Yeah, I was just gonna say, is the
Well, I
property
think
located in?
I think what he wants, this may be one of those questions where you have a yes, no, unknown box, where you would say, is the property in a groundwater district? Yes, no, unknown.
I like that.
You did, I like that too, but you just switched something though. You didn't ask, and I like what you said, but you didn't say as a seller aware. You said, is the property?
No, that's what I'm saying. The way that this may be appropriate question to change that, to
Yeah.
have an unknown box. So
That fits within kind of the
idea,
existing statutory structure without creating an additional
okay.
burden. Is phrasing in a different way to highlight the question better, I think.
So we would say then, is any portion of the property located in a groundwater district? Yes, no, unknown.
And y'all want the unknown because y'all don't want them to have to just do one quick Google search, figure out which on the map, because I've done this a million times, and just look on your tax statement to see. You don't want them to have to do that, right?
That's one of the easiest things to find. And of all these things, whether it's in there or not. So
But the only thing easier than finding it is saying, I don't know, unknown.
So going back
So if we
to,
take off unknown is what I'm saying, it might make them.
going back to the property code, though,
I see.
because this is in the seller's disclosure. Of course, seller's disclosure doesn't apply to every property that this could be attached to. You said it only has yes or no and that. So could there be a discrepancy if they still have to fill this out, even if they're filling out the seller's disclosure, they're going to put no on one and unknown on the other?
it states, are you seller aware of the following, right? Yes, if you are aware, right? No, if you're not aware. And at the bottom of the list is any portion of the property that's located in a groundwater conservation district or a subsidence district. So that's how it's phrased in the statutory language.
Or can we, can we phrase it where we don't have unknown, where they have to just, or y'all don't want people to have to go?
That would be how we have it now before any changes. They have to say yes or no, but it's based upon whether they're aware, which is again, the statutory.
But if we're switching it to is the property located within, not the seller aware, but is the property located within, I like that phrasing better
They have to go
than
up.
take off the unknown.
I'm a little hesitant taking off unknown.
It can be easily known.
Yes or no? So you have a lot of situations, I think, where sellers are simply not aware of that. They don't know whether it is, and it may be. So I have a
I agree
portion.
with that.
I have a
I think
portion.
you're now philosophically different. I want them to go be aware.
So I think let's start real quick. Do we want to heighten the standard that's already established in statute? And that's kind of the fundamental question. If so, then we can tinker with the language. If not, which is what we already have, if not, we want to stay with the standard, it would be what's drafted right now. And I'm personally uncomfortable changing up statutory disclosures. And that's what we've done already to draft some language for consideration. Gives me pains that we went beyond where we had to, but I would like to limit that and to keep the burden the same way, to not create additional burdens where we don't.
Yeah, I mean, I guess the devil's advocate to my own self would be, if you put unknown, even though there's this notice, now it's brought it to my attention, so now the buyer can go do their Google search.
That's okay. All right. So then the next question is seller aware of one or more water wells on the property? And then I think that's pretty straightforward.
I do have a question on that, or just bringing back all the conversation with SJ was on 2B3, the number of water wells known to seller that are not currently in use and have been capped, covered, plugged, and abandoned is. And I just remember she was so adamant that sometimes there were some that were not in use that were not capped, covered, plugged, or abandoned, and that needed to be counted as well.
She sees a lot of that because her husband's a major broker with Republic Ranches. And in that farmer ranch world, we do see a whole lot that I guess you could say are abandoned and not properly taken care of.
Sure.
Does
it need to be in here is my
Yeah,
question. I mean, I don't know.
I
the
remember
answer to that.
vaguely on this is that we got into the question, into the detail about, all right, when is a water well not in use? Well, temporarily, it may not be in use. I'm just not using it now, but everything's operating and it's okay.
Mhm.
I haven't abandoned it versus I have abandoned it or I have capped it. So I think she wasn't worried about the ones that were temporarily not in use.
I think when you hit abandoned, that covers everything.
Right.
Because that doesn't mean it was covered or capped. It just means, I think that's why we added the word abandoned.
Okay.
That's how I recall the conversation too, because if it's been capped and covered, plugged, it wasn't abandoned. They've intentionally taken care of closing it off. Abandoned is the one that's just sitting out there that could be uncovered.
Right.
Yeah, that-
Okay. Okay.
That's right. You're right.
Yeah. I think that makes sense. So make sure we were all good.
All right.
Yeah.
And if in C, if the answer to D2, which is the number of wells known sellers are currently in use is yes, then the following, complete the following to the extent known. I think those are pretty straightforward.
Hey, John, it's that section of the property code with the, are you in a groundwater district?
5.008.
And then D, is the seller aware whether the property receives water from a water well located on another property that's not in a city or district or supply water corporation? And then E, is the seller aware of a water well on the property relies in whole or part on groundwater rights owned or leased from land outside of the boundaries? And again, these are just, I'm aware or I'm not aware. And then whether or not any groundwater, the last one, F, is whether or not there's been any severance of the water rights. All right. And then the changes, of course, in coming primarily from number 3. So we'll strike complete to the best of seller's knowledge and belief again. And then A is the seller the owner of all or part of the surface water associated with the property? Yes or no? And then you identify those applicable rights. And again, you're going to have a certification number or permit number or something along those lines.
So I have a question on in 3 when it talks about identifying any leases. Does that go back to the natural resource lease in the 1-4 when it talks about providing a copy of natural resource leases? Is that also, they would also have to provide that according to the natural resources leases in paragraph 4 of the 1-4?
Correct. They have to, if
Okay.
they have I believe that's if they're a party to that natural resource lease. So,
And would
but if
that
not, if they're
include-
not a party.
And that would include any leases if if someone's leasing water from a well or anything like that as well?
Natural. Let me go back.
I think
to
so.
that.
Well, it depends if it's on the property or not on the property under 4, right? Because if it's on the property, then the property is subject to the lease.
Right.
But if it's not on the
Yes,
property.
something real quick. Existing. Yeah, it's lease affecting the property to which seller is a party. So both those elements have to be met for the requirement to be triggered for seller to provide them in the farm roads contract. So if it didn't affect the property, it doesn't matter. It's not whether it's on or off, it's just whether it
It
affects.
affects the
And
property.
then second though, in many of these cases, seller is not a party to that document, right?
That's right.
So it knocks out a lot. Like, for example, oil and gas leases from 1930s have been transferred a whole bunch of times and severed. It impacts the property, but the seller's not a party to it in any way. So those wouldn't have to be delivered. Now, looking how does that fit into your initial question? Do you mind stating?
Well, when it was talking about water rights leased in F, is there any sort of tie between those two? Because in F, it talks about, if yes, describe the groundwater rights severed, sold, or leased.
So that would be a little broader in a way and a little overlapping in a way. If the seller's the one who leased the minerals, or in this case, the water, they will be a party to that lease and it affects the property.
So that would fall under also paragraph 4,
Exactly, where they already have to provide a
a
copy.
copy of the
for.
lease.
Now, let's say it was in what we're most commonly used to in oil and gas lease from many, many years ago that the seller doesn't even know about other than seeing it in a title commitment maybe in the past. That's would affect, if we know about it then, it would, and it's for a lease of water rights, then we would have to disclose it on here, but we wouldn't have to provide it under the contract because we're not a party to it.
Okay.
And both those obligations in the contract haven't been satisfied to trigger it. I think I'm looking at that.
The seller's not a party to it, but underground where his house is, and he's selling it, there's water leased from ages ago to others. But doesn't he have to disclose that?
I think that's where.
Well, if he knows
says
about it,
here.
yes. So could have been severed. Those water rights could have been severed. And he may not know about the leasing that takes place later, or he might, depending on, I guess, where the well is.
So the form is asking if he's aware or not.
Right.
And
That's in
will
there.
that, and I think you said it wouldn't necessarily come up on the title commitment. Well, why not?
So title commitments do not go into the chain of title for leasing of minerals. They generally have a general exception that, they may or may not point to oil and gas leases, or they may have a general exception to any oil and gas leases and being very broad here, but there's some language that's used commonly. In Brian can, if I'm saying anything too off basis, can chime in and correct me here. But having that, you wouldn't necessarily get, and most of the times don't get, a list of all those leases that are in there. So you may never know about it. Once it's severed and goes down a separate chain of titles for that mineral right, sellers often don't know.
So to make sure I'm not summarizing and over like generalizing, F in the water notice is if they're aware of any lease, whether they're party to it or not, they just mention it for the contract. Natural resources is if they're a party to it themselves.
Exactly.
And it affects the property. Okay. I just wanted to make sure I understood the difference
Yeah, that's a
between the
great
two.
question.
Right, good question. And then,
One comment before we go on from 3A, I just had in my mind, and this is how I read things to make it more clear, but is the seller the owner of? We use the kind of does in the other ones. I don't know if we want to rephrase that, does the seller own all or part, to fit in with how we
okay,
use the term later.
Certainly easier to read.
so let me get to the right. What do I do with my form here? Oh, here it is. Since I'm making the changes on the so we want to say, does the seller,
Does the seller own any surface water right?
If that covers everything there.
so is that the question then? We're just to be that broad, does the seller own any surface water rights?
Right, and then below, we split it out to identify each person in their respective ownership interest. So we later dive into that splitting of hairs, whether it's all or.
Do we want to say associated with the property as well? Continue that?
I believe so.
Okay.
And the bullets underneath, it shouldn't be 3AA. It should be 3A1.
One, yeah. 3A1, yeah.
Mhm. Because in the first one where it says identify the applicable surface water right and it's
Right.
permit, after that blank, it says if more than one person owns an interest in any surface water right identified in one. Where's one? Doesn't exist.
Yeah, that should
It's
be,
supposed to be A1,
Mhm.
A2 was if more than one person owns, and A3 was, do you intend to reserve?
okay. I'll make those clear.
Mhm.
Okay. And then 2, does the seller intend to reserve all or any portion of any surface water right identified in 1? So,
Wait, Ron, what?
Wait, the
I'm
2
sorry.
would be if more than one person owns an interest, and then 3 would be does seller. It just got popped up behind that line.
Okay, that's what we wouldn't do that.
That's right. Formatting.
You're on your game today.
I'm trying to get out there by noon.
She's like, come on.
I'll make that change, okay?
Instead of just 1, do we need to state 3A1?
I think so. I think that's a good thing, yeah. Okay, so then that brings us down to 3A3. Does the seller intend to reserve all or any portion of the surface water right identified in, let's say, 3A1? Okay, any comment on that one? No, okay. So that's the first time I think that we have in
I do have one thing on that one. Down below under notices to buyer and seller, on 5, it talks about if anyone is wanting to reserve any water rights, they should consult an attorney. Should we put some of that language with that? Like if they do, if yes, please, you are advised to seek an attorney, or should we keep them separate? Or should we bold down below number 5 under notices to buyer and seller? Because I think that's very important. Someone think that just because they put yes here, that they intend to reserve, that they're actually reserving them.
well, that raises a question for me on that. Is this the first time that we've had in a disclosure notice an expression of intention to reserve, which is typically reserved for negotiations?
And that's the
So,
second point here.
If
Besides,
I'm asking $1 million for the property and I said, yes, I intend to reserve it all, but I get an offer of 2, I may be willing to let them go. So I don't know if that doesn't, I mean, that just discloses an intention. It doesn't disclose a fact, right?
and this too is provided with the contract. And so presumably the reservation of any surface water right should have been negotiated and already established before the execution of this. So that beyond the actual language being right, with Ron, I'm not sure this is appropriate to include here.
So maybe
because
we
of-
need to just take that out altogether, because that would have already been negotiated.
How important is that, Brian, to you? Because it's going to be negotiated in the contract if there's a reservation.
This is area where we see a lot of problems arise. Because nobody, the default when it comes to surface water, which is what we're on, the default when it comes to surface water right is if I convey the land that's recognized in the surface water right without reserving it specifically, it conveys. The surface water right conveys with it. If I have a piece of property that was a 1,000-acre cotton farm on the Brazos River, it's now been broken down into a number of 10-acre tracts or 100-acre tracts. I sell part of it, my 10 acres without reservation, 10 acres of the surface water rights loss, and we start a fraction process over at TCQ. Or you can specifically say, I reserve all the surface water rights for the recognized under certificate of adjudication number such and such. Okay. These concepts aren't new to you. I'm just telling you that nobody, plenty of folks aren't sophisticated enough to decide whether they're intending to pass their surface water rights along in this transaction or not. And we're just trying to get what's your intention?
So,
And then you get to what will now be right under it after we get rid of all this stricken language. The notice 5 here, if you intend to reserve, you should consult an attorney because
the problem though, is this would be filled out and sent back with the contract itself, right? It'd be
Or
filled in and
afterwards.
wrapped. And so and so they would have already contractually made an arrangement that included or not included that right or the surface or water rights in general. And so that is to me, we're a little late in the game here to be making notices, and it can only create issues, I think. All these things would have need to be done up
let me
front.
explain that to me again. I'm not disagreeing.
So
What's in my mind is, this is what we're intending to do. And what's going to need to be, and we're going to need to address that in the warranty deeds that go with it, these reservations.
So this is only intent, it's not a contractual obligation, and this will accompany the actual contract or be provided after the contract.
Why is it after the contract?
Because if it's not provided, it can be done,
At the time of contracting, I think he's what he said.
or within so many days after, right? So we would have already had the contract, and there's not an obligation to
Okay,
provide it
now-
up
now
front.
I'm
So
with
would
you.
that,
Okay.
could that go in K, just a note that if parties intend to reserve water rights, they should seek consultant attorney? Should that just go in the contract somewhere in K or not at all?
Well, we don't do that for minerals, right? And minerals are long, and I know there's particular concern with water and how it's being reserved and some big issues in the state. And so I understand the need to bring it to attention. I'm just not sure this is the vehicle with how it's developed, or even putting it in the contract wouldn't really belong.
It doesn't belong to this notice.
Okay.
Whether the seller
I mean,
intends to do something or
You could put, if you wanted to, down in either the notices below, but we already kind of do that, is to say, if you want to intend, or if your intention is to reserve, do X, Y, Z.
And I think 5 captures that.
Yeah, except that you're saying it is my intention, which.
No, I'm saying 5.
Oh, 5 does that, yeah.
Captures
Yeah.
that.
So
I understand what y'all are saying now. You've already got a contract in place probably before they get this, so what does my intent matter? And so I guess we could either just strike it all together, which sounds like the prevailing deal, or
okay,
we could say,
Yeah.
identify the portion, if any, being reserved. I'm fine with
Yeah.
that.
we have had, these are some old cases, but on the seller's disclosure notice where people put in certain things, they used to put in there things like, this will stay or this will go and things like that. And then someone relied on that statement and they basically got tossed out because it was not in the contract. So,
Okay.
so we'll keep, is there a pond or lake on the property? Yes or no?
So on that one, that brings up
The
the
dry
discussion
one.
about the dry and tanks, and this is where I refer to the brokers and farm and ranch.
Actually, it's.
Tony, you want to take this one?
So, yeah, I'll take it. I got, I like what Brian's trying to do, kind of keep it simple. The vernacular, use a bigger word, keep it simple. In practice though, I mean, everybody south of I-10 is gonna call it a tank.
No.
And are they gonna say it's a pond? And then you're gonna say, yeah, it is. Probably could get over not using the word tank. I mean, if you want to put a parenthetical, a pond is a tank. But I think you're okay without saying tank. But you definitely need to probably hit the dry thing, or we need to at least discuss it more, because there's so much down there, all over Frio County, Medina, Gonzales, everything. You're like, well, there is a pond, but it doesn't have any water this year. Do I need to say anything? It had water last year. It actually had,
What if it said, is there a pond, tank, or lake on the property regardless of whether it's currently dry or full?
look, I mean, that would cover everything.
Yes or no? Because we just want them to think, again, the implications of this are nothing. Yes or no?
Right.
If yes, just be aware that you may need a water right to use it.
And
right.
there's certain, just for knowledge and discussion here, it depends, not every pond, tank, or lake require a permit. Some of them have, I'm not sure the exact bounds, sounds like it's subject to dispute, but let's say you're pulling water out of a state water source. You're pulling water to then feed it. That kind of brings with it the need for the permit because of where you're getting the water. If it's built in a certain size or certain thing, then it's may not. You may be able to capture the diffused surface water in it and still maintain that ownership. But even if it's that, and then you fill it up with some of the state water, then you can start triggering these. It's really complex in that
Well, that's a good point.
area.
Because most people that I encounter, again, south of like 10, or they've got some kind of groundwater source or some other source that they keep it pumped and keep water in it. They may turn it off, may turn it on, but they're using other than the Lord and Mother Nature to keep it water in it.
Well, in like East Texas, having the big fracking ponds, that people are, leasing their property or letting come build these big, huge ponds or tanks or whatever they're technically called, and filling them with these big water wells and then selling that at it's a big business out there.
I mean, that would
So
cover it
that's-
if we wanted to do it tank, dry or not.
Okay, so I have, is there a pond, lake, or, and I'm assuming water tank, we should say, a water tank on the property?
Yeah, stop.
You want a stock tank or water tank? No? Okay.
Just a tank.
Tank.
I think water tank.
Is there a pond, lake, or?
They've got a Sherman tank on the property and they
That's only the ox.
have to deal with
That's
that.
the ox ranch.
So,
That one in Navasota.
I do like you saying water tank though.
yeah, is there a pond, lake, or water tank on the property, whether currently with or without water, is what we're saying?
Water tank or just tank?
No, we,
Whether dry or not.
It says water
Whether-
tank, didn't say container. I didn't
don't
think
want-
about general
Whether
knowledge.
currently
whether dry or not.
dry or wet?
That would actually be the correct way to grammatically do it, but.
Whether dry or not.
And Corey, since you brought that up, set language, did you have any thoughts on language?
Should it- since
Did
you're-
that good at you? Okay.
You actually made a good point, dry and wet, should it be empty or not?
Well,
What about partial?
that's why I said with water or without water. That's why, to me,
And it
that's,
covers
Maybe
everything.
we
in
say
between.
that,
yeah.
Yeah.
with water, without, instead of empty, dry, wet,
Yeah.
with water or without.
Just marshy.
Okay.
Trying to stay succinct here because whatever you change here, you got to go change in your disclosure paragraph.
Right. All right. Then I think that just brings us to the 5 notices, which I don't think were changed. And so the question came out, do you want to bold number 5?
Yeah. I like the idea of putting number 5 as bold,
I do too.
or at least the
At least the
consultant attorney.
yeah.
Well, in the spirit of SJ, I could at least say we need to put it in all caps bold. Put my phone number in there.
Okay. And then we can look at the 7K paragraph real quickly. So this will be the triggering mechanism in each of the forms about this notice, the water notice. So access to surface water or groundwater on the property may be regulated, restricted, or prohibited, including but not limited to the right to drill or operate water wells and the right to withdraw water from surface water sources on or adjoining the property. Parties may use a water notice published by TREC to identify information related to groundwater and surface water rights. So here, the same thing like in the seller's disclosure notice, the buyer has already received the notice, or the buyer has not received the notice, and then the same thing is that he's got so many days to deliver it, and the rights to terminate go along, mirroring what they do for the seller's disclosure notice. And then number 3, this will be the one that will require most study by real estate agents after this form is adopted. Because if I'm, as Brian mentioned, if I specialize in only in working in a city, then chances are I know and I'll get educated to say, oh, this doesn't apply in these cases. But I have to be careful. So seller's not aware of a water well on the property. So that's the first thing that has to occur. I'm not aware of a water well on my property. Seller's not aware of a pond or lake on the property.
Or tank.
Or tank,
Tank.
okay. Okay.
Whatever you do in one, you got to do
So,
in the other.
to each one, the lead in, one of the big questions and common issues that have been raised to me about this and misunderstandings is that all these have to be true.
Yes,
And-
yes.
And after each of them, just like we do. in the
Oh.
law.
Well,
No.
and my thought is at the beginning, leading to seller will not deliver the water notice because all of the following are true. Just put a short statement at the beginning.
All right.
There, that just seems to be a very common misunderstanding with the current language.
Okay.
That's better than an and after each one.
Yeah.
And then
Yeah.
C, seller is not aware of any certificate of adjudication, certified filing, or permit for surface water rights associated with the property administered by the Texas Commission on Environmental Quality. D, seller is not aware that any groundwater rights to the property have been severed, sold, or leased in whole or in part. And the property receives water only from the following. Should be from one of the following, right? One or more of the following.
I see what you're
I
saying.
like one of the, yeah.
No, because we're naming the municipality in the blanket.
Oh, that's
The
right.
Following municipality model.
Okay, I'm sorry. Yeah, that makes sense.
Yeah.
Okay.
So I do have a question back up in K, the last sentence, it says the parties may use a water notice
That's what I was
published by
just
TREC.
Oh,
So if it's a voluntary may use, what other water notice would they be using?
What if you have an attorney that says, well, it says.
I'm sorry, I couldn't hear.
That's a good point.
Oh, go ahead, Chrissy, again. Sorry. I couldn't hear.
The last sentence of K is the parties may use a water notice published by TREC to identify information. But yet if it says in one buyer has received the water notice, what other water notice opportunity do they have? We're using may, so the question is going to come up, well, what are my other options? And what needs to be contained in it? Because it's not statutorily
That's a good point.
required. And do we need to change the wording of that? Because they would have to use, basically, we're telling them they need to deliver it if all those are not true.
This may have been drafted too at the time. I know there was a bill introduced that would have required disclosures like this that did not go through. And so there is no other form right now. We don't have any directive on what would need to be in the notice, which is exactly your point on. I think we had to point them to the one and not may use that, but you have to.
Do you want to do you want to just take out the whole sentence?
I think that's safer. I'm afraid since we don't have a statutory mandate or a new bill, that we might be running around if we put shall.
Well,
But if you take the sentence out, it's like, this is the only one there is.
But they also need to know what, I mean, obviously in education, will let them know that we have one, or complete track addendum or water notice.
We have to identify the water notice, and we just take out the sentence and just say has received the water notice. We don't have, it's a capitalized term, but there's no direction like there is in that sentence published by Trek.
Okay.
And so maybe if we just use the parties must use a water notice published.
You want must or
The
shall?
water.
I think shall's the proper term,
shall.
right? For this.
We have to, there's another one where must and shall come up in some different language, but yes, that's the right term.
Okay.
Shall use.
The water notice, not a.
Yes.
Or
Should we
could
use the
you,
exact term?
or could you just say take out that sentence and say, see the water notice, seller's disclosure, and just the title written by Trek? I mean, we're not.
Where at?
I'm saying instead of the parties shall use or whatever, just at that, just say, see this title. Oh, I'm directing them to the next form.
I think it's too vague.
Yeah, it's not too much of a, I think a little more lead-ins needed
Okay.
here.
And we did have the conversation yesterday about condominium contract because the owners they own it,
That's a good question.
joint ownership. Can we discuss that?
Yeah, Brian, there was a question yesterday about whether this should even go in the condominium form. We have a residential condominium form and didn't really know the answer, whether that needed to be in here or this notice need to be delivered if
I don't know that I'm the best one to answer that question. 'Cause I don't understand condo. There was some form and I thought it was the condo form that we had not included all this paragraph in. One of the forms that we had, is that one we had included it in?
I think it's in the,
It is in what.
Abby,
we
do you
have
remember, is
now.
it in the condo draft right now? So the,
The condo's on page 97 of our materials.
so my thought is that most condos are going to be in municipalities and those associations are going to tend to own special water rights if they have something outside of if they have something outside of a municipal water district or a mud district or something else, or if there's a special water thing that someone who's built 40 condos, 50 condos, and they've created their own little water supply corporation. So I guess the same thing would happen, but are there condos out there where are small enough to where these will be issues?
I don't know the answer to that question.
Okay.
I see them all the time.
Condos?
In fact, we've got one going in next to where I live that is, because they didn't want to subdivide the property and get around the subdivision rules, they're putting little condo associations, each one on one septic and one water well.
It's happening all the time here. That's the thing in Austin.
I now
There's
have
a company
an
that
opinion.
specializes.
Please include it.
Okay.
I mean, after the legislature 2 sessions ago started requiring groundwater availability certifications that have to be performed by an engineer or PG. If properties are if a subdivision of properties coming in before a platting authority on groundwater, they're coming up with all kinds of little clever things. I just don't, sounds like condos could be one of the clever things they come up with to try to circumvent those rules.
All right.
There's one particular lawyer that advertises she's done over 2,000 condo regimes in Austin and San Antonio alone. So
2000 what?
condo regimes, these little
Yeah.
properties that she's
Yeah.
describing. That's,
Okay, so that concludes that. And then
okay. So do we want to take a short break here and then come back? And in my mind, I was thinking an hour and a half for this, an hour and a half for the
he's so optimistic.
paragraph 12 issue. And then, that's kind of my lunch plan. So I think if we're on track, we can come back and maybe review the language in the minutes to make sure we covered it. But take a 10-minute break and come back at 10:30. At 10:32. Okay. Mr. Sledge, have you have a suggestion, or do you need a little more time to circle back on?
I'll try.
So we're going to spend just a short period of time. Corey raised a good issue on, we use groundwater rights throughout this document without defining a groundwater right. Unlike we define surface water right and use it throughout, and that might cause confusion. So it's a good thing to bring up. And so I tasked Brian in about 2 minutes time to come up with a solution.
Yeah, I don't think there's a definition of law. So I'm going to keep, I prefer to keep it simple. Groundwater right means legal right to drill for, produce, or use groundwater from real property.
To drill?
There's a distinction though between surface water rights and groundwater rights, in the sense that surface water rights, you don't own the surface water. The state owns it. They just give you the right of use.
Correct.
That's why you use rights. But I don't think you need to say that with respect to groundwater, because you're the owner of the groundwater, subject to regulation as to how you can use it. But the ownership is, unless severed, it's owned by the person who owns the surface, right? Or whoever owns the groundwater. But you don't have to say groundwater rights. You don't have to say who owns the oil and gas.
As we use that term throughout the document, though, let's see how the context gets used, where the questions might arise.
So it's an F.
So there's where the groundwater rights
You still don't think
to the property that happens sold, dot.
But it's a small R, so if you had like,
You want to add a definition of groundwater.
Or just look at whether it's needed to stop
Well,
confusion.
instead, groundwater ownership.
Ownership. That's,
We have that in A, unless severed from surface estate, groundwater is owned by the surface landowner who may be able to access groundwater by drilling.
now you can still own it and sell a right to it, right to use without selling, leasing it. And
So then maybe it does become groundwater ownership for the property had been severed, sold, or leased. Since that would fall in alignment with what Candy just said about the definition we already have for groundwater, the note underneath it.
I like rights because I'm just thinking if you've got a profit, which is the right to withdraw water from the well, but you don't really have any ownership in it, it's just a right to use it. And we use the word rights when we talk about oil and gas rights or air rights without defining it with capital R.
The term groundwater rights is extraordinarily common in my world and in all groundwater district regulations. You either have a fee simple estate in the surface estate or groundwater rights associated with the acreage or whatever. I think all you're asking is, it's a term we use, so let's define it, or let's not use it.
well, just prevent confusion was more, it may be a solution or a problem that's not a problem, right? This was one just to raise since we're looking at this of anticipating questions, and we may just want to monitor this and not change anything else. But if there was a way that was reasonable to put something in.
If you would,
Yeah, but what
if
you
you would
just said-
define it, I would say groundwater right is the right to drill for, produce, or use groundwater from real property.
And I'm not sure we need to go there.
I don't need it.
I think with the note that we already have in 1A, it didn't stick out to me before.
Okay,
I don't know that,
let's monitor that. It's good to bring up and talk through, and we can monitor that. And Corey, if you, I'm sure you'll let us know. if the line goes hot on that
Anybody
issue.
that has sold, severed, or leased the groundwater rights from the property will know exactly what that term
Yeah,
is.
exactly. Okay, so we can jump now. Are we ready to go to the
Yep.
Just if you give me,
paragraph 12?
you can introduce it where you are.
Okay, so
Am I done?
yes, thank you. I want to thank you again, Brian, for your this was, I know, a lot of hard work on your part in pushing on your side, pushing on our side, and thank you very much for everything you do.
I think it was worth delaying the adoption.
It will be, yeah.
We'll get this out
Yeah,
in
I like
2029. 29 and it'll be in use.
Okay.
You make me wait until the next legislative session, and we'll put an earlier date in that legislation.
Well, thank you again. We'll jump right into paragraph 12. Overnight, has some more thoughts. This is that evolving concept. And again, I go back to when we first did paragraph 12, we said we're taking a first step. And whatever step we take today is maybe the second or third step, and it won't necessarily be the last step again. But we've had a lot of feedback in analyzing the feedback we originally received, what we have now, the changes to the industry that were highlighted yesterday in terms of the commonly used association forms changing. I tried to think of a way to grab the best of both. The best of paragraph 12 that everybody's come to like, and the best of everybody originally requested and still generally likes. And what I have a proposal to stick on the screen for us to shoot holes in. But it attempts to do just that. And one request that's incorporated in this proposal when it was put up there is to make it mutual. Why do we just have a buyer's ability to contribute or seller's ability to contribute to the buyer? What about the other way around? And other than adding words to the page, there's situations and quite a few that may make sense. What we have in the farm and ranch is outside the actual terms of the contract. It's down below and it's its own separate agreement. And so we don't want to create separate agreements more than necessary. So looking at moving farm and ranch up into the contract, and how would we do that? One distinction between farm and ranch and paragraph 12 is paragraph 12 is a contribution to the buyer. The party's not paying, the seller's not paying the buyer's broker directly. It's a contribution to cover some of the expenses that the buyer's required to pay. What if you read the farm and ranch language, the farm and ranch language is saying the seller is paying the buyer's broker, or the buyer's paying the seller's broker, right? And so we have a few different concepts to marry up if we're looking at the paragraph 12 and farm and ranch. I like the contribution language and not paying directly. I like keeping it within. And so I tried to move the language up into paragraph 12, have it mutual where each side can contribute to the other, but keep it as a contribution. And at the same time, highlight that the contribution, the party's agreement to pay their own brokers is outside the contract. That's in a separate agreement. And to the extent allowed by that agreement and by applicable law, the parties agree to contribute this to the other side's broker's fees. To keep it in very plain language as I could come up with at night, and to capture that concept. So that's what I've done, try to do here. This is intended to be, if we go down this path of removing the current paragraph 12 language we have in regards to the broker fee compensation or contribution. This would become C, because we have 2A and B right now. This would become C in that same section. And it's broker compensation. Starting out as not set by law. I'll let you read it.
Ron?
Mhm.
Little zoom for.
Oh, I did.
I know you did.
A little bigger zoom.
You're already zoomed.
Oh, sorry.
But let's see here. Let me try it again.
Run the class.
Zach, I need to move up. Thank you.
May
You
read
say
it.
this is C, but there, now we're talking about the 1 to 4, where compensation is discussed, contribution to is in 12A1B.
Correct. So we would take that out of B,
Uh-huh.
and this would be a separate section regarding, in that same sub, in 12.
Right, so you have this, what is B now, if this is C?
So B is the,
If any expense exceeds an amount expressly stated in the contract for such expense to be paid by a party, that party may terminate this contract unless the other party agrees to pay such expense.
which is a separate discussion on that paragraph, I think, too. In order, it's not a big deal, but this would be a
He's
separate.
asking what's gonna be in 12A1B.
And so that's,
Nothing. Well, it would move
Yeah.
up,
oh,
right?
no,
C
so that would move
back
up. Yeah, C would
Right.
move back up to be the catch-all, and it still would not apply to brokerage fees.
And
And
would we,
brokerage fees would be covered in this
Can I go back
section.
where it used to?
and we
Yeah,
state
okay.
that,
I want to make sure,
If we-
that's what I thought, but I didn't hear it, so.
so if we moved, if we did this and moved C up to B, it would still state that it does not, any amounts in there do not apply towards brokerage.
Exactly.
Okay, I just
Mhm.
wanted to clarify.
Yep. And so, and we would need to tweak, I think instead of fees, we do compensation personally. So
Yeah.
changing compensation in that where it doesn't apply to compensation up there, but otherwise keep it the same.
And John, did you say there is something that says if there is a separate agreement, this is not, do not sign or do not?
So this says, the second sentence here, it says broker compensation not set by law and fully negotiable. The terms of the parties' obligations to compensate their brokers are contained in separate written agreements. So that gets at the buyer's rep and the listing agreement is what's in the intent by that. To the extent allowed by these agreements in applicable law, now we have, you know, the agreements say I can only collect what I'm, you know, charging in here. And then we have association rules that come in there, and we have the new Senate Bill 1968, which is encompassed in 563 of having to set out the amounts that you're charging. Right, so we have these things. So to the extent allowed by those agreements in applicable law, the parties agree to pay the following. And I kept the concept of a contribution in here instead of paying directly.
So my, initially on looking at it and hearing what you stated we would do with the rest of the paragraph 12, my first thoughts are, I like it, but what stops the agent upon reading this? They're still going to put in their compensation from their listing agreement in here. I see them doing
And
that.
I
Sure.
was trying to come up with some language to put in there. So if we can get some good language for that, I would love to
Yeah, that's the only thing I
preemptively
see.
avoid the issue.
I just want it clear that this, they
Maybe
should not
pulling that
include
second
any
sentence.
compensation negotiated directly with their fiduciary or client.
So could you pull that second sentence from C and make it its own big, bold term that, so that basically, if I'm a seller and broker, I have an agreement with my seller outside of this contract. If I'm a buyer's broker, I have an agreement outside. This is only,
These are in addition to
In
any
addition to
agreement.
what we
These
have.
amounts are in addition to, but no, that's not in
No, that's
addition
not
to.
true, because I'm trying to get the
No.
seller to pay. I'm not trying to get my buyer to pay.
Right, and I think that's I don't, even though it's clear to me that the terms of the parties' obligation to compensate their brokers are contained in separate written agreements, our agents they still want to see and make sure, they're so afraid they're not going to get paid, they're still gonna put their compensation that's in their
But they
listing
can't.
agreement.
here.
And
They
this
can't.
agreement does
Because
not
that's
change,
seller's
this
buyer.
paragraph does not change those agreements.
And that's what I was about the same tagline in this, however we say paragraph, but this does not change the. That's where I was struggling last night, exactly how to state that.
Yeah,
Yeah.
This
But this
paragraph
only
does not.
offers seller to pay buyer's broker and buyer to pay
Well,
seller.
I
So
think-
we've got that here. There is no seller is gonna pay selling broker an additional amount. It's seller will pay buyer's broker.
Right, and that's
So
why I took out
that-
Farm and
that's
Ranch,
the
I took out that
the other
chopping
one, the
off.
second one, yeah.
Well,
So this-
the way to do that is if you put a paragraph in here that says exactly that the seller will pay the seller's agent pursuant to their separate written agreement. And then you have these choices here regarding the buyer's agent.
I tried that exact same thing, some of my drafts that I was
You
working
didn't like
with.
it?
It got a little wordy, but I was concerned about brevity and it ended up here, but
No, we need
I was in
clarity.
that mindset,
Clarity
in
for
part of the
sure.
drafting, so.
So if you put in here,
What's the purpose of this? Is it to get a contribution from the seller, or is it to state what the
Seller's
agreement of
broker.
parties are?
To get a
In a
contribution,
separate
To get a
agreement.
contribution.
not to state what the underlying agreements provide, not to state that my listing agreement is,
Mhm.
you know, X with the seller and my buyer rep agreements X with the buyer. This is for the contributions from.
The purpose is to get,
Can
you
I
have
ask
something
one
in writing where the
question?
seller is gonna pay the buyer's commission and around all the other regulations and the
As I'm
TL.
reading this,
Diane, think about during the
Hold
pandemic.
on, one conversation.
all I'm seeing we're doing is we're moving the broker's screw up and confusion from paragraph 12 to paragraph 8.
And making it mutual and trying to help clarify the
Well, I mean,
language.
but moving the mistake from one paragraph to the other is not accomplishing it.
And that's why we're gonna try to prevent it from being a mistake with the language, right? That's the
What will
ultimate.
happen with the farm and ranch? If this was a farm and ranch contract we were looking at, will it change the same way as this?
No.
No. So here's the
Why are we
farmer.
having two
here's the farm-
different modes of?
No, this would,
Because the farm and ranch people seem to be able to get it a lot easier than you residential people.
Okay, let's be nice.
I'm teasing. I'm teasing.
This is a very serious
because-
issue with the brokerages.
It has to be different.
We've got to get it right this time.
So the reason it has to be different is you have to have now under 1101563 of the Texas Occupations Code, a written agreement with the buyer that contains certain things. Oh, but that only applies to residential real property. And residential real property has its own definition of, it's a single family house, a duplex, triplex, or quadruplex. It does not include all farm and ranch property. So you can have farm and ranch without that. But if you have a residential property for purposes of 563, you have to have a termination date. You have to have whether it's exclusive or non-exclusive, all these different things. The farm and ranch contract doesn't have that. A lot of people are using this as their actual agreement to get paid, right? And that's, help me if I'm wrong, that's
Correct.
the actual agreement getting
That's
paid.
correct.
And so they want that vehicle to use to be able to get it right there in the contract itself. And with all the other, the 1 to 4 and unapproved and all that being residential in nature, we can't have that style. So we would have to change farm and ranch up to meet this and take away something that they currently need. And we can't use farm and ranch over in the 1 to 4 because of the new rules.
Yeah, but this is, I mean, now he's changing it all on me, but what it did say is it said, seller shall pay such and such to the buyer's, but then on the next section, it was buyer will pay such and such to the seller.
That's right.
All we've done is gone, okay, I'll pay 3 and you pay 3 and we're back to the regular written agreement. I mean,
And then
I don't
area of
like it.
confusion.
I don't like
I
it because
don't
it's
either.
not doing anything.
So what about the argument about making it mutual? Right, so right now we have buyer is ability to contribute to freedom of contract thing, right? The buyer's able to contribute to seller's able to contribute to buyer's compensation or buyer agent compensation. We don't have the reverse. We don't have a buyer. Think about short sales. Think about other situations to make a better offer.
Or in
And people would
2020
use
in the
that.
pandemic, when people were like, I'll pay the other side fee, right? Like buyers were freaking out trying to buy out.
And so we have the concept of wanting to allow and facilitate these contributions. I don't see any reasons as a general matter why it shouldn't be mutual. And that's one of the farm and ranch concepts that I really liked. I really like that concept.
I don't think this will.
If we go back to what our role as Trek is, what is this for? The consumer, to make them understand who's paying what. What Ron just did, I do like this because it spells out who is paying the seller's agent. Is it the seller or is it the buyer? Who is contributing to the buyer? Is it the buyer or the seller? It could be both. And it's spelled out. There's your choices.
so you have boxes
Okay, let me
here.
read this one.
Okay, this looks different. Okay.
We'll have boxes before A and B.
Seller.
So can we take off in the first paragraph the part about the written agreements? Since we put them in 1 and 2.
Probably need to do that.
And I think I agree with you there because it sounds like it's duplicating. an agreement that could be different from what is below? Is that your point, Christie?
Yes.
Okay.
By the way.
Well, it doesn't need a checkbox in front of that. That's just a statement. That is,
No, that's the one that you're gonna select those.
And we're looking at 12 right now. It being in 12 just behind excess expenses, but it can be, I think if we like the concept, we can look at whether 8 or 12, and then 12, where in 12 we put it.
so I'm not understanding putting checkboxes where seller shall pay seller's broker pursuant to a separate written agreement between seller and seller's broker. That is true and doesn't need a checkbox.
Well, in 90% of the cases, but then you don't have the option there for the buyer to contribute to the broker, to the seller's.
Unless you use the checkbox inside.
See, I think this
C
box
one
right
B.
here in residential transactions is never going to be checked.
Right, and.
It might be checked somewhat in farm and ranch. I don't know farm and ranch well enough to know.
Well, it
Why
might be
wouldn't they just
checked.
leave it blank?
It will,
It could
I
be.
think it will be used if the vehicle's there, and there's been a request I've had recently several times, again, the short sale situation being most common, but in other ones, making a prettier offer, that's.
Are we complicating it by adding something that is hasn't been used to this point? Now we're introducing something new. You're gonna have people sitting back, what's that about?
I think it
There's
is.
a lot of
It is
requests.
used. It is
It's used. I have one
It's
just
used.
last night that the buyer says, I want to pay for it, even though
We have
the
it
listing
too.
agreement says that the seller is paying the seller side, the buyer said,
They
I'll
want the
pay
house.
everything. I'll even pay the compensation.
Yeah, they want the
Yeah,
house,
investors
multiple
do it too.
Yeah,
offers.
this was an investor.
Mhm.
They're ensuring that they're getting the property. They're paying the listing agent's fees.
So the other
I
alternative.
do want to go back to the
I'm against
checkbox
that.
too.
So the other alternative that you
I'm
do.
with you. You're just adding the possibility of more complexity because there are few deals out there where buyers are offering to do this little bit extra.
So-
But now you're introducing that concept for all the contracts.
And for the
And
seller
now
to
it-
see that
Now
and
it
ask
becomes
for.
market, that is something that the parties are gonna be discussing.
So this would be the other alternative here, is that you just default that the seller is going to pay the seller's broker.
And then they do the same on the buyers.
Well, here you have the buyer is going to pay, or you're going to have a contribution, or both.
Now, the only challenge here is because you're using seller's broker or buyer's broker, and you've got companies that will not pay the brokerage. They're putting it on their CD as a contribution to the seller
Right. And that
or to the
is-
buyer. You know, the compensation goes in under the buyer as a credit,
Which is
whatever
what
you
I
want
thought
to
you were
call it.
doing
But that's
They're
not
not-
what it says.
Not,
It just says that it will be applied toward.
I
So
don't see
they're saying-
applied.
Now
Yeah.
that
Under B, right there, applied toward. So they're not saying I'm giving it to them. I'm giving the credit from the seller to the buyer, and the buyer must designate these funds to be applied towards this.
I think 12 is starting to work. I would not go and add more chaos to 12.
Well, that's what we were changing already though,
And
right?
this is where
Yeah.
we go down to the fork in the
Apply
road,
toward.
right? This is the opportunity to do a more substantial change if we are, otherwise it's going to be a while. And there's been very strong voices about, I wish I could, John Holland's, voice in the back of my head. But he's one of the loudest ones on making it mutual, but there's a lot, if you go out there and monitor the market, there's a lot of voices that want this mutual. You're seeing it, you're seeing it, I'm seeing it. It's, I hear everybody shaking their head. There's a lot that want to make it mutual. So that's its own decision. If we don't make it mutual, then I think a lot of these changes probably become a moot, and we look at, keeping 12, but that's the farm and ranch style context. I got that from the mutuality of it, having it in the same section where you're looking at it all together instead of as an outpost.
So
this
here's-
does those two things.
Here's farm and ranch.
I love farm and ranch, but as a reminder, I mean, you know this, but just as a quick reminder, remember, most of the time, Farm and Ranch does not have the backing of realtor forms. We're not using that. So this is all we're working off of. And I'm with John. I love that it's very mutual. And I think this is very simple to plug in to residential and alleviate some situations. But like John said, if we're not making it mutual, we're going to kind of tear this up. Well, then we might as well just stick with what we got for 12B.
I guess my question is, and I mean, I'm in a city, I'm not in the rural areas and farm and ranch and all that stuff, but okay, I guess my question is, right currently, we still get those stupid phone calls, how much are you paying us? Okay, they don't know how to negotiate, we still get those stupid phone calls. And secondly, they get irate if that number is not what it has been for the last 40 years.
They're gonna have to grow up.
But remember,
Irate. I mean, I've had brokers not send contracts to title because I'm not agreeing to the right number. And it's like, it's not me, it's a buyer and a seller that's agreeing.
But remember that the practice is about to change with listing,
Yeah, the
as Texas
listing
Realtors announced
agreement.
yesterday, 5A, where you're allowed to contribute to the other side is going away. And so
Right.
that's going to take that out. It's already been, I think, in my experience, a practice of fewer and fewer using
You're
that
right,
procedure.
okay.
But now with the
Absolutely.
complete going away, it
Oh,
hopefully
I
will, the
can't wait
first
for those
question
phone calls.
take care of that. Melissa?
I don't run into nearly as many issues as she does. I'm in the Dallas-Fort Worth market and we are not getting, hey, are you offering? We just don't get those phone calls anymore.
Oh,
And we're a
all the
big
time.
market and we just don't get them.
We're not getting,
All the time.
We are in Houston and we're getting brokerages refusing to use the only vehicle realtors have, the 2402. So they have no idea what the amount is. Well, just bring me an offer. And so the agent is at risk that they're going to write a transaction and receive nothing from anybody.
That's gonna.
And we
That's
got
not
the
true.
first
They're gonna
time.
negotiate
Negotiate their
That's
buyer
not
rep
true.
agreement.
They just have to be able to negotiate paragraph 12. If I say, bring me an offer, it's like, Melissa, have some brains as a buyer's agent and bring me an offer, understanding what the compensation is. She knows for the last 40 years, most cases,
Yeah.
what we're gonna do.
Well, I'm gonna put in.
But
what's in
if
my
the
buyer
seller
rep
says I
agreement.
want 50,000 below and 20,000 in closing costs, oh, and by the way, still give me my full compensation. That's a Melissa
I
issue.
don't
That's
think the
not.
world's gonna be there the same way it was 4 years ago. There's been too much
Yeah,
Yeah, I
legislation,
agree
too
with
many
that.
lawsuits. I think the agents are gonna have to digest.
Well, the brokers are.
Well, hold on.
Yeah.
Is that Christie?
so I think that we need to be on the cutting edge of this because with Texas Realtors announcement to us yesterday of what is coming, we need to go ahead and plan our forms around that because
Yes.
5A is going away, and that is what a large majority of people use. That will automatically change the mindset of the people y'all are working with. Like Melissa, we're not nearly seeing what you're
Yeah.
seeing and what y'all are seeing in Houston. They're starting to morph that mindset around negotiating in the contract. And I feel strongly about including and making it an option for the buyer to pay. Why are we stressing that all of this has to be on the seller without the buyer being able to contribute back the other direction? Let's be progressive.
Melissa?
I also think that's like the crux of the whole drama with the lawsuit was all of the expense was always on the seller, on the seller, on the seller, on the seller.
Mhm.
And we have to be, I like that you said cutting edge, but I also know that it all came about when the market shifts. And I think as the market shifts, the check boxes will be shift, right? Like it's gonna go one direction or the other based on what the market will
and we're
bear, and that makes the contract better.
So here's another alternative. We just come out and say each party's going to pay their brokers pursuant to their agreements. And then you have the choice for contributions to be applied from one side or the other.
John, tell me, or Ron, tell me why we can't take, is it the 1101? Why we can't take the exact language from Farm and Ranch?
So I have a concern with the farm and ranch language. Well, twofold. It's a different concept in that a party is paying the other side's broker directly
Oh, that's right.
instead of a contribution. And
Yeah, yeah.
second to that
Yeah.
is 563 requires XYZ to be in a written agreement for residential properties.
Okay, thank
And-
you.
and
You know,
that-
Yeah, okay. I don't want to make you dwell. I got it. Thank
So
you.
here, it all works by contribution. Each party pays their own broker. I may or may not get reimbursed from the other side for part of that or all of it.
That looks very simple.
The only
Okay, I like that one.
Yeah.
I like that.
only concern I have that's not included in here that I was trying to incorporate in the original language is, let's say the contribution amount in here is more than what's in the buyer's rep.
They just have to
And-
amend the buyer's rep.
Right, but that's already an established contract, and there's no indication that is going to be capped. You know, that cap concept that we have in 12 right now, and
Yeah, but I mean, you can't stop that from happening no matter what.
that's a thought. It's
Now,
just
you
whether
could
we
put a
want to
warning,
preemptively
don't
address that.
exceed the amount that you put in.
Well,
If
who
you
gets
put a
the extra
warning, I don't
money?
know.
Well, isn't
Right,
that
at
what
the
it
end,
used to
that's-
say?
Well, no, I don't know what, we've had several drafts.
No, but wasn't it on a TR form that said not to exceed what we put in the agreement?
We had that in
the
our.
binder.
We tried to
Something.
put not to exceed and the backlash was ridiculous.
Oh, yeah.
The comments back were like, what?
Yeah.
Well, maybe this sets its own cap too. I mean, thinking this through, because it says applied to the broker's fees owed by seller to the listing broker. It's in, by its own language, setting the cap.
Right.
If you don't owe it, it's not being applied.
Or if you get it, then so what? You don't pay it to your broker. I mean, those are gonna have, I think the brokers are gonna run the risk of exceeding that, and others have to face the consequences if that happens. I don't think it'll happen very often, because I think A is not gonna be checked. B will be checked. And in the typical residential deal, it'll be the
Sure
only one.
is simple and to the point.
And then are we gonna still put in that the closing costs cannot be applied to this? The
Yes,
next
so in
section?
C, we keep the
'Cause
language.
we gotta
in C.
keep that.
Yeah.
We've
buyer-
gotta keep that.
Well, yeah, that makes sense. So John, were you thinking that under 12A1C, as we move it to be B, to keep it buyer's expenses other than brokerage fees and an amount not to exceed blank? Because that's the current.
Exactly, but change fee to compensation. Just to make it
Brokerage
uniform.
compensation.
Yeah, I like compensation.
Yeah,
instead of
I like
fee.
it better.
Yes.
Well, let's see.
And-
I'm-
buyer's
I'm
expenses other than
confused on
broker's
what
compensation.
to add here, so why don't you tell me
Yep.
what to?
Yeah, we're finally on.
Let me make sure nothing changes here. Hold on.
Comment I would have is, the suggestion would be the second sentence after C. Adding at the end of that sentence, the specified amount does not change the party's obligations under those agreements. I know it makes it a little more wordy, but just emphasize.
It kind of makes more sense though.
Which is,
Yeah.
Brian had brought that up.
I'm sorry, where do
you
you want me
say
to
that
put
again?
that? Let's
Sorry, I
put it in
couldn't
here.
hear you.
Go for a draft.
So at the end of the second sentence, just adding something along the lines of the
Right there.
specified amount or the amount specified below does not change the party's obligations under those agreements.
Mm-hmm.
Will that reflect what's going to be in the listing agreements?
Right, so that if somebody puts a lower amount in here, it's
Mhm.
not reducing
Their
what's in your
client,
listing
yeah.
agreement or your buyer
The
requirement.
client doesn't
That's very
think
good.
that
And as
they're.
we think about how this,
Yes. Yeah.
how this agreements operate is, and the buyer's rep says the buyer's paying their broker X. I'm gonna go try to get it as a broker from the other side, but if I don't, buyer, you're still responsible for paying me X.
Right.
And the listing agreement is a little different, but it effectively, those are hard and fast agreements in terms of what's being paid.
I
And
like
with some
that.
offsets on any amounts that are contributed, at least on the buyer side.
This almost seems like it should come after A and B, after we check box A and B. To me, because
Yeah, it would stand out more too.
Well, I think it should be bold.
I think
I do too.
Yeah.
I'm in agreement with Melissa.
Glow in the dark.
I'm
Bigger font.
Yeah. Bold, all
Specified
caps.
above.
Just kidding.
Do you want
The only
to
thought
run it,
about
or
it
do you
being
want-
where it was is that before they look at
Should
the
be C1
numbers,
and
they
2.
know that that doesn't change the obligation just referenced.
Is it gonna be 1 and 2 or A and B? I guess it's gonna be 1 and 2. We need to change it at the top.
Does is do. Or change
Or
amounts.
change amount.
Yeah. Kenny, you were kicking butt today.
It should
like
be
the gold star. on her eyes or
I'm
something.
telling you.
It's these gold pants.
She's like an English professor proofreader.
I think that sentences, I think because it says, pursuant to those agreements, it's too far away from the sentence talking about those
Yes.
agreements that it won't get read. I
Agreed.
think they
Yeah.
need to stay
Good
together.
point.
Yeah,
Put that back.
And just,
Back up.
yeah, and change it all back, Ron.
Put it all back up top.
Yeah,
Yeah,
because
you
we-
might
had it right the first
we
time.
don't have a lead in here.
Just put it there.
All right.
So I used the lead in that buyer will pay and seller will pay is our lead in effectively now to the broader section.
Evo, do not change.
Yeah, 12A1A. 12A1.
Oh, I can't wait to see this happen.
I do think that last sentence would be great if it could be
I mean,
bolded
I
for our
can
clients.
I read Grover's hold up contract.
Can you vote?
Do you think the sentence 2 should be 1 and 1, 2? The seller contribution that they're more used to should come before this new aspect of the buyer
I like that,
contributing?
yeah.
Can we keep it 1 and 2 that way?
As parties' obligations to pay the compensation, this is a pay compensation.
It's almost like we should have-
C2 below. not change.
Oh, okay. That's kind of odd how we start that sentence, right? When we put it that way.
I have a formatting question. A second.
Oh, that's good.
Do you want this as a contractual term or just a note?
No, that's fine. By the way, if we're getting rid of 8D, this isn't gonna be C, it's gonna be B. Is that correct?
Well, we're looking at 12 right now. I think you're thinking about 8,
Oh.
but there's a debate with that. So Abby, what's the?
Well, so you've got in 12A, it starts out, the clause is the following expenses must be paid at or prior to closing. And then you've got 1 for seller expenses, 2 for buyer's expenses. And then B is separate from that, and it talks about the fee. I'm wondering if you need to
Make
have
this
some of the
12B.
language in A, or if you're wanting to incorporate some of that language into C.
The one thing I like about keeping it separate is it really calls it out instead of being drowned in the middle of what we have. And I do see what you're saying on,
The at or prior to paid at or prior to closing. I'd also note, we don't have titles before A or B.
I think what we should do.
that's where I thought the title would be still helpful.
we do, but it's in parentheses at the end. Seller shall pay the following expenses, and then it says seller expenses. Maybe that should be like a header. Yeah.
And I'm not sure I like the word the application of. I think that's going to be misread potentially by agents, that the application of those doesn't change the party's obligation to pay their agreement. I think they're going to say that, well, even with this applied, you still owe what's in your agreement. I just think that that's going to be misinterpreted.
The word application.
I do.
I was just gonna try to get the copy of the whole thing over, but it came out this way to kind of give us a look at what it's gonna look like altogether, but it didn't format real well when I copied. I'll have to get the rest over as well. So you see, we don't have any lead-in paragraphs over here, John, that are named.
But could we reformat like 12A1 to say seller
Oh,
expense?
sorry, my C, or I was thinking this starts with C, below, even below that. So we then have
Capital
E, which
this
is
C.
excess
Capital C.
expenses.
Oh, over here.
Yeah,
is-
even below further.
Okay, so what you're saying,
After the.
I would almost move it to, I was going to suggest removing excess expenses. I've never seen that used, and I don't know if it serves a purpose, and that we could make this its own B.
Capital
No,
letter
that,
B.
I think that's better.
And so it's tacked right along afterwards, but right now I put it at the end, just to.
But
that's
you
what
would-
this is.
But you would take out that B that's in there then, right?
no, this is buyer's expense.
That's why I was getting confused with the C.
No, the little
I
B.
think-
But I see what
12A1B.
you were
Oh,
going.
this one here?
Yeah, that
goes
B
away.
you would take out and put in what you just put in.
No, I
He
think,
had it separate as capital C,
Correct.
12C, capital C.
And the other thought that I had was in 8 right now. So we're talking about, we need to take out 8B regardless, because it's conflicting. We have agreements about compensation that are in our contracts. So 8B right now needs to be taken out regardless. So
Yeah.
if we add
It's
it
already
there,
there to go.
it's under the broker section, but it's separated from the
Closing
the
cost.
closing cost. And so there's a debate there. And I went back and forth thinking about it.
I can understand that, but I can see all those questions.
Yeah, but remember, we put into paragraph 12 that seller will pay brokerage fees that seller has agreed to pay.
Yeah, as
And
one of
buyer
their
shall pay
costs.
brokerage fees that buyer has agreed to pay. So it's already in paragraph 12. And so if we put it in paragraph 8, that separates this whole stuff about brokerage compensation away from paragraph 12. It makes it clear, this is what the deal is. It's in a separate section, but it still works with
I
paragraph.
like it better
It's an
in
easy
12.
sell on
I like it
that.
better in 12.
I like it a lot better in 12. I think 8 is just putting you on notice that one of the parties to the transaction has a real estate license, right? Or is related to. And I kind of just like it just being like, this is about the relationship, but 12 is about the fees.
Yeah.
And 12 is absolutely the fees that must be paid at or prior to closing.
so I was just showing, so I guess the first question is, I was trying to show where you want to place all this. So you want this new B here,
I would take out, my suggestion would be us looking at taking out B,
this B.
right? Or moving
I think-
that to C
make
and
it
putting this
C.
B, right?
Make it
Exactly.
C, yeah.
So if we maintained it, we could just move that down and then
Make that the
make
C.
the new stuff we're drafting B.
What, and then take out above, the B above.
Right. Yeah,
Well-
that'd be part of the
Change
N12A.
B to C and move that up.
We have too many subsections to keep it straight.
So you don't want this provision here?
We can move that to C
Yeah.
in what we're discussing to B.
Quite honestly, if we're talking about 12B, what do agents think about with compensation after a year and a half? It's 12A1B.
It's just gonna be
just the
12B.
12 and the B is going to just be easier to.
So you're, do you want to just,
Make that
We make
B.
that B. I
Make
just
that
had it
B.
as C. That wasn't-
does it matter that this is titled, this paragraph and the others are not?
I like it calling it out, but
Yeah, it needs to be.
Titles to the others.
that's true.
Yeah, that's what I would rather do is just.
And then I would
after
take out
seller's expense,
12A1.
buyer's expense.
Because we're not gonna have that up there. 12A1, no, 12A1B. We're gonna take
Yeah,
out.
that's gonna be, that has to for sure. We'll get that.
And then the other question is, do you do 12AC, put it under compensation, or do you put it up there? Because they're not gonna see that from here to here.
It's about
Cause
their
C,
money.
cause
They
C's
will.
Yeah, they will.
I think they will.
Money.
And I think 12A1B was for concessions for 100
Every
million
year.
years.
Yeah.
The other
Yes.
suggestion, since you're in there, Ron, was to change fee to compensation. And it appears right there in that sentence you're working on, other than brokerage fees. The broker, I think all the brokers like that, changing fee to compensation.
Yeah,
That's fine.
And it's also in the definition of buyer's expenses.
Yeah, it's a word
Yeah.
that we've been
So-
schooled to use.
Yeah, I
So
think
is
it,
the one I'm working on in the book different? The one I see in the book says buyer's expenses other than broker's fees in an amount not to exceed.
Yeah, we took out not to exceed
yeah,
because a
no, it's
lot of,
right here.
everybody screamed at that one.
Yeah, because it was
didn't come
negotiable.
out in the,
Right.
when I brought it over in the
Okay.
formatting, is what happened. Right here is not to exceed. Through here.
Well, B's actually buyer
Mhm.
expenses other than brokerage fees in an amount not to
The
exceed.
sentence is flipped
Yeah.
in the one in our book.
And I think we changed that last time.
Mhm.
So I think we can change.
Some of this came out because we made changes, so you'll see these parentheticals showing strike-throughs. That's where the confusion comes in, the way I have it. I should have copied this from the existing form as opposed to the changes that we made. Does that make sense? But all of these coming out.
Right, I think what we're looking at here in C is how C starts here versus how it starts up there. Is that what you're looking at, Christy?
No, little c.
Yeah, oh yeah, little. If you go back up to the top, right, what is now the new
Now
B?
B.
Yep, and seeing how we changed it.
Oh,
Yeah, it's right here.
okay.
And other bracket goes away.
So we have here, what am I doing? An amount. So I'm missing something here, right?
Correct.
That should-
It's flipped on how you have it. You say buyer's expenses as a capitalized.
Oh, you know what
Other
happened?
than-
You know what happened is, I think it, because these were strike-throughs here.
Do you want to put compensation there?
Yes, yeah.
Yeah, I need to,
Oh, that's the one that has to be there. Okay, never mind. That's when you're striking out.
it must have been a copy error that I had or something. Right?
It was,
That's what
yeah,
it says.
yes.
Is that what it says now? Except,
You don't need the to be applied to.
okay. That's what it says now.
Correct.
Okay, so what I'm gonna do is make this. So we want to change now fees to compensation. Now, the only hesitation I have on that is the fact that I think in the listing agreements, do they still use brokerage fees or compensation?
I believe it's gone.
On the
more into
listing agreement?
compensation.
I
We
just-
use compensation a lot, but I can't say for sure.
If it's,
Mm,
We'll use compensation and broker's fee. So,
I think the instruction has been to start using compensation rather than fee. At least that's what I've heard. And
Yes.
Yes. We title it broker compensation, but then we refer to it as broker's fee, so.
I think it's just because we're used to it, but most people are getting over to compensation. It's to be in the safe.
Yeah, well, number 5 says compensation, but then in A, it says broker's fees.
And when
So
that comes out-
It's like a,
we can get maybe consistency when that bigger change is made to Texas Realtors forms to make it compensation.
Chloe, what word is going to be used in listing agreements?
It's, well, in the future, I don't know what it's gonna be used, but in the most recent one, the title for 5 is broker compensation, and then, basically the sentence this kind of sums it up. Broker compensation is fully negotiable. Brokers significantly determine their fees. So we really just use them. both.
Yeah, they have 2 words in there.
And then throughout, we use them.
I would
I
just say
personally like compensation.
I would say compensation, because I think well, if you take A out and then they're just gonna go to B, they're just gonna have to change broker's compensation.
So then do we need to change
Period.
brokerage fees that's in,
There's 3 places that
there's
need to be
multiple,
changed.
yeah.
Well, that's gonna be in all the forms as well, so.
Right, the definition of buyer's expenses at the bottom has a,
So just for stylistic reasons, in subparagraphs, when we title the subparagraphs, yeah, we use all caps, okay. So did you want to put titles on this one, like expenses and then,
Yeah, that all stays the same, doesn't it?
well, we don't have I mean, you could do this.
seller expenses,
And then you could,
buyer expenses, and then brokerage
you could do this.
compensation.
I don't know if you want to do this or not, but
You know, if we typically have titles that far down.
yeah, typically, the only reason why I thought that was the case because now they are defined in those parentheticals there.
I see what you're saying. So just the top would be,
I think that would be a fresh approach. I like that.
So take these out.
Stands out. And it's used elsewhere. I was looking in the contract to see where else it, all caps was used, and 13 has it. So
broker compensation,
it's important enough. Buyer's
and
possession,
then excess expenses, the last one.
smart devices.
It's 12B.
Oh, yeah, thank you.
And then my last question is, do you need to add for now brokerage compensation when it's paid at or prior to closing to that paragraph? Since you're taking it out of A.
Limits. I need to see what the limits on.
Limits is,
Yeah. Or limitation.
So you wanted to call this excess expenses?
Brian suggested limitations.
Limitations.
Expense
on
limitations.
prohibited expenses. Expense.
Would that work? I don't know. I'm sorry, we needed to put something in here for authorizing escrow agent to pay.
No, you needed a, since A has the following expenses must be paid at or prior to closing. And now you've moved this language into B, if you need to copy that language to B.
They would be paid. Does ever be paid before closing? I'm trying to think if we, I know that the standard language is at or prior.
I think we need something like that though, because I think one of the association forms might be alluding to payment for closing in the future.
How about that?
Melissa, would you repeat that?
One of the association forms might or might not be alluding to payment
Do you need
before
a-
closing.
Brian, do you need an authorization that
With the
says that
opportunity to
escrow agent shall,
accept a retainer.
that works like
Oh,
that?
correct. Well, it's in that now.
What about the
Right,
farm and ranch right
which is What
now
I'm saying.
has the last sentence in that little blurb is seller/buyer authorizes and directs escrow agent to pay the brokers from the proceeds at closing. You know, that-
We're not paying the brokers though, right?
Yeah,
We're gonna,
we're paying the buyers.
Well, it's authorizing the escrow agent to pay the brokers in general from the proceeds, I think, as opposed to.
oh, I see what you're saying.
Yeah, so the problem is that it considers that, the farm and ranch considers that a separate agreement.
Right.
Right.
which I think is a problematic, just from a drafting standpoint, I don't like that at all. And it should be one agreement, the contract, right?
Sure.
I don't know what I'm doing here.
We can format it.
Okay, you know what I'm doing here.
You just need to be able to.
In A, we had, when we put all this stuff in originally about compensation, we added that brokerage expenses that seller has agreed to pay are seller expenses.
So broker, like
And brokerage fees that buyer has agreed to pay is a buyer expense. I don't think we need that anymore, do we?
If you
one
go,
more fee there.
yeah, go up a little bit,
I think we do.
move it, move the,
Because that's not an
Oh,
expense to pay. Instead,
But it's still an expense that the consumer has to pay based on their separate written agreement, right? If it's not fully
There's one more
covered in
place with
this,
that in the
contract,
number B, that
won't they
long
still have
number,
to-
it's covered
uh,
in
Oh, down
subsection
here?
B, right there, yeah. Broker, next to the last
right
line,
here.
above.
It's covered in B that each party shall pay their respective brokers.
okay.
And the reason we don't want it to be there, because then it could be interpreted as being a double dip
Yeah,
if the seller is paying some of the buyer's broker's compensation down in paragraph B, but it's still an expense.
that makes sense.
Under
Yeah, to only
A.
have it once is fine, I think.
Got brokerage fees in 1 and 2 as well.
Oh, okay. That one, since that's new, I'm just gonna take it like this.
Can you help me understand the reasoning behind using the application versus the amounts in 12B1 and 12B2 don't change the party's obligation?
Or the payments.
The payments,
The application of the payment, is that what you're saying? We've
I just
applied
want to
the
make
payment.
sure that this is not confusing
an
to lay
applied
people
payment.
reasoning.
Contributions would be I had contributions in my initial language too, and I recall the discussion back in my head saying we didn't want to use contribution, but I think it's fine because that's exactly what it is. It's a contribution
That's true.
to it.
do you want to say the
But could
following
that, I'm
contributions?
I'm not trying to be irritating. The contributions do not change the party's obligations to pay compensation. Could someone interpret that to say, if you have the seller paying 2% below and they owe 3%, or could someone say, well, it doesn't change what they owe in their agreement, and I'm also getting this?
Right? So the stacking effect.
Yes,
is
I can see people saying they're gonna stack it based on that language.
But it's to be applied toward the brokerage compensation.
The word is implied. We have to, yeah.
Yeah. I just
Are
wanna make sure.
applied to and do not change? Are applied to and do not, kind of having a dual,
That's, do not change the amounts in those separate agreements.
are applied to, because then that means it's going against them.
And we're
And
back
do
to
not
the
change what those are, so
Yeah,
then you at least have a
that's
little more of a
clarifying.
concept.
I'm just hoping we don't have to revisit this, trying to foresee all the comments that are gonna come in.
That's good. I'm glad you raised that because it ended up with that, which I think is clearer. I think one nice thing about this is it's totally different than the farm and ranch and what we've had before. And I think it's heading it's in the right direction.
So now it's contractual
Yes,
as opposed to more of a notice.
with initials at the bottom of the page.
And listing broker doesn't need to be capitalized like buyer broker does.
Well, yeah, I was going to ask you, what are the terms we're using? Seller broker?
Seller's broker, didn't we change that?
Yeah,
Buyer's broker and seller's broker.
What's,
yeah.
Yeah, page
Sellers.
We
I think we took
broker
the-
firm in there.
I think we took it.
Define, put it as seller's agent.
Yeah,
Yeah,
but
it just says
buyer's
seller's agent. Yeah.
But I believe in the, what they paint we did.
So it's actually paid to the broker, right? Not to the agent?
Yes,
Okay. An agent, I think, is being used in a broader context, but it is confusing. So we do use agent, meaning the same thing as we do here in different parts of the
Right.
contract.
But we have a whole part about, we're circling back in that legal 1 and 2 to tell them it's never paid to the agent, it's always paid to the broker.
But you're also gonna then put C in there that the buyer's expenses, other than brokerage fees, we don't have that in there.
It's there. It's in C up above, which is now the new
Oh,
B.
okay, got it.
Yeah, and the lead-based paint, we use seller's broker and buyer's broker.
Okay. So we have
Thank you.
precedent.
Okay, now,
Can we,
Ron,
Mhm.
I don't believe in we should have any mention of the brokerage compensation being a seller expense or a buyer expense. Because our new paragraph B is totally different.
So you're
I
going
see what you're saying.
So how would you word that? You would just,
of course,
You have two semicolons.
Of course, you might have the question of this catching those contributions amounts. That's all right, though. I think that's just, you live with it. So then we have to take it out down here, right? Where's that?
And we had added it in there when we made the change before to at least the definition of buyer's expenses.
mhm. So go back up to A, where it says expenses, the following expenses must be paid. That only applies to A. Should we use that sentence, the following
It's there.
expenses? No, back up. That sentence after A, expenses. The following expenses must be paid at or prior to closing. Should that be at 12, settlement and other expenses? Is it, I guess my question is that only meaning the things in 12A? What about the things in 12B? Are those also paid at or before close, like it's?
So what
Yeah,
would
we
be,
added that sentence. We added that.
We could probably take it out if we had it that they were.
Shall be
Keep
applied
it
at
out.
or prior to
Oh,
closing.
at,
It's
wait,
just not-
must be paid at, like the following contribution must be paid at closing. Yeah.
Okay.
Yeah, because these would be the contributions that would be paid, but the other payable by them under their separate written agreement, they could pay in advance. Okay, okay,
Now,
yep.
Go,
Following.
Ron, go back up in A, where you talk about the seller paying buyer expenses. We no longer need that other than brokerage compensation.
Ooh, I think
I think we do.
No, because it's no longer a buyer.
there's so much confusion though in the argument
Yeah.
before was even with our old language, without adding it there, that it could be used for that.
Yeah, they were using it. Agents were using it.
That's one that I agree with you shouldn't be needed, but
is in
Is
practice.
in practice.
Let's be redundant.
yeah,
Yes.
yeah, that's.
Yes.
Okay, so B, the buyer expenses, and there should not be.
Okay, good.
Because if they didn't like what, well, now we aren't gonna have to tell them anything. But when we were telling them the wrong number, they would throw that other
Mhm.
in that.
Well, any other amount in that paragraph,
Yep.
in the second one. Mhm.
Okay.
Do you need it zoomed in, Tony, so we can do one more last proofread?
Yes. I mean,
You want me to proofread it?
I'm kind of just letting her handle it.
Oh, she's your proofreader now? I
Yeah.
got you, I got you.
I really
Does that
like
mean
it.
you're gonna have to get glasses?
I should have brought them. Actually, I'm farsighted, but my contacts were so strong, like I could see a mosquito flying 1,000 yards away, but I couldn't read a laptop. So I had the eye doctor dial me way back. So now I can actually look at a screen and not need readers, but now I can't see the screen over there.
Yeah.
It's an age problem.
See, I'm the opposite. I have to use these for this and then I have to take these off to see that.
Ron, how do you handle these situations?
I mean, they
Oh,
tried the
You just sit
bifocal.
closer?
I'm not saying, yeah, I get like this.
Well, they
Actually,
tried
as you're
the
talking, I went to the
bifocals.
doctor last week
Yeah.
and he said, I got to zoom up your prescription.
They can't hardly get me anymore at -9.
The biggest challenge, I tried the bifocals to be able to do that.
Subsection B.
Oh, it's so hard.
I was getting sick.
I tried multifocal and I was
Percent
getting
extent.
like massive, like nauseous and
Yeah.
dizzy.
Ugh.
I couldn't do it.
I couldn't do it.
No, they.
Then I would start wearing them like this,
Oh, yeah.
because I could,
Me too.
and then if I had to look up, I went like this. I did my own bifocals.
Oh, when I did the cataract surgery, I had the multifocal, so I had no choice. They're inside now.
You're
Yeah, I
inside.
was gonna say that.
Ron?
Yes, sir.
How hard was it to
It's
use?
elective now.
The next day, it's fine.
Oh, wow.
What took a while was the halos in driving at night. In 6 months, that went away.
Take it out here.
I'm 20/20
The
vision.
apostrophe.
No, no,
I
just
wish I
add it
would have
to
done it
this.
sooner, but he couldn't.
Because we have.
Oh, up here, the way it was.
Apparently it's popular now to get the cataracts surgery.
We had it at the
Elective.
comments.
Do you want- I've always thought, should we bold these right here, even though I know.
Oh, gosh, what was it?
Well, I thought we were gonna maybe
Call
move
this-
that to the front and capitalize it
Yeah,
so that
it
it,
was the same thing.
oh, well, I guess not, because we're making that a
We can
capital
leave that
letter.
elsewhere.
Never mind.
Can't remember what it was.
Okay, well, I'll leave that to the illustrious formatting committee.
Oh, just a reminder, I'm getting a few messages that the mic picks up the side conversations pretty well, so.
Oh.
As a
Is it-
reminder.
Is one of the commissioners on
So
here?
behave yourself.
Yeah.
Is one of the
Look how trouble we're
commissioners
gonna
on
be
here?
in. What is what on?
I
there?
said, is one of the commissioners on here? I would love their opinion.
Commissioner Lowe has been,
Yes.
yeah, she's been at all of our meetings consistently. Okay, let's give it a,
I would just love an opinion.
Do you want me to, you
Conversation.
want to print this out or anything?
that would probably be good if we
Yeah.
print it out, give it a
Trying
good
to-
read and.
Mhm.
Okay, so let me
I
stop
think I have
sharing.
it all in here, but I'm not sure. I tried to copy
You
it.
wanna?
Yeah, if I can figure out how to move this thing, there we go.
Because I needed to put it all together. I couldn't. Yeah.
Let's do it. Oh, there we go.
Oh, look at all of our guests today.
Look at all the people on here.
Well, I did do a video.
I've got to save it. I didn't have this saved.
They're listening to me.
Well, Tracy Shores is, Tracy Shores likes 2 cameras, huh? Linda Ramsey, these are educators. Judith Bunchy, these are all educators.
So I think looking at next steps, if we review this, then we go back to review the minutes to make sure we make the right changes to the water disclosure issues so we can make sure the minutes properly reflect what we agree on here. And then Diane wanted to bring up an issue with the HOAs and
Heidi,
disclosures. And then I think we preserve the paragraph 9 defaults, times of the essence issue, defer that to the next meeting so we can.
And the seller's disclosure, is that moving forward? I just had a question about positioning of those
Yes,
additions.
it is. So if you want to go and bring that up actually while we're turning, do you want to go and bring the issues up and talk about them now?
Anytime you
Yeah,
want.
let's do it.
Now?
Yep.
Okay.
Yep.
So on our HOA addendums, we're on page, looks like 110 and 111. The HOA addendum, we talked about this before. I think those changes are great. The only thing I noticed is effective date in 1 is not capitalized. Effective date in 2 is.
I think that's a good.
I'm sorry, I got distracted for just a second. I want to put these there for the minutes. Can you repeat that for me?
So
On page 110.
110 in the Property Owners Association addendum,
You
there's
wanted to-
effective dates not capitalized only one spot and not the other. We capitalized in our addition that we made, but it should have been capitalized originally in the old version.
In A1, yeah.
Capitalization of the term effective date,
Correct.
and it should be capitalized?
In A1.
Yeah, A1's not capitalized and A2 is, so.
And in just the Trek box at the bottom where the form numbers are mentioned, I believe 3610 should be 11. And
Where?
36.9 should be 10.
Where are you?
I'm in the
It's a little
box
bitty
at the
box.
bottom. It's
Oh my
the
God.
standard Trek.
Yeah, because it always has that like
Thank
chain
you.
of
Oh, I would have never looked at that stuff.
Diane.
Thank you, Diane. I would have never looked at that.
What was the other one?
And on the seller's disclosure, I just was questioning the placement of the blue line information. It talks about insurance and easements, and I just wondered if section 6 is talking about insurance, if that was just put there as a convenient place to put there, or if the insurance issue should be more together. The first 1, 2, 3, 4 items seem to be talking about insurability of the property, and so is paragraph 6 talking about insurance. Just ease of reading, unless that paragraph 6 is about floodplains, and that's why it's all by itself. But
That's what I would read. 6 is all floodplain. And while we're on the disclosure, someone made the comment about generators. Do we need to put anything on here?
Oh, no, I've been firmly against adding more than we've been requested by the
Right,
Sunset
so-
Commission.
All right.
yeah.
Diane, I'm sorry, I need to get this for the minutes. I was trying to find the right form. So you want to move on page 3 of the seller's disclosure notice?
Just questioning for our review if section 6 talking about present flood insurance, talking about insurance in general, and then the grouping of information that's being added does mix questions about insurability, flood insurance, windstorm insurance. Should we have insurance all in one place? Was there a rationale?
Well, I can tell you that my recollection as to section 6, that was mandated by statute. That was added. And so they put that section in the form specifically that way, if I recall correctly. Whereas
Okay,
this one came over as instruction from
Sunset.
Sunset's committee.
okay, well, that handles that.
Okay.
Thank you.
All right. And then you had previously mentioned one other change, and I missed something about the bottom.
The numbers at the bottom referencing forms, Trek number 3610 should be 11 because that's what the new form number will be.
Okay.
And the form that it is replacing is 3610, not 9.
Yeah, we usually do that. Thanks for catching that. We'll make sure that's updated.
I'll just put in there to make a note to do that. Okay.
This actually sounds good.
Don't seem so surprised.
Okay.
Are we going back to 12 now?
Yes, I think we're going back to review the.
We have a bad sentence structure. What does in and out not to exceed modify? Does it modify other than brokerage compensation or buyer expenses?
Should be comments.
I guess I'd say buyer expenses, comma, which does not include.
What is this be under A1B, buyer's expenses other than brokerage compensation and amount not to exceed? Is this that buyer's contribution?
We're kind of going back to 12A1B like it was way on back.
And we're looking at the sentence structure. Brian's thinking about a way to, as it reads right now, what's the in and amount not to exceed modifying?
Yeah, in an amount not to exceed blank. Does that modify brokerage compensation or buyer expenses?
Can you
think-
put parentheticals around other than brokerage?
Well, if you flip the flow of that sentence and say B, in an amount not to exceed blank, buyer's expenses other than brokerage compensation.
Well, the whole,
Because the
whole
the
point
sentence-
of brokerage compensation is not a buyer's
For
expense.
years.
So
before.
seller shall pay the following expenses. And then you have a B, is the next part of that sentence. Seller shall pay the following expenses. I'm sorry, the following expenses must be paid seller shall pay the following expenses. And so maybe a portion of the buyer's expenses or
What if we say, just throwing out a new idea,
contribution.
buyer expenses in an amount not to exceed blank with parentheses do not include brokerage fees? Because we already have it out of the definition. It's not a defined buyer's expense, but just have a direct do not include brokerage compensation.
Well, do you want to also go along the lines that you were talking about in terms of it is a contribution? In other words, seller shall pay the following expenses, seller's expenses, a contribution to be applied to buyer's expenses.
In an amount not.
Yeah, in an amount not to exceed.
Okay.
Yeah, let me pull it up here so that we draft.
On the banking issue.
Banking issue. But it is at the end of the day, contribution though, right? Even though it's the interested party.
It's just the wording
contributions.
bothers me on that.
What would leave it expenses? But
I personally like that better. That's,
Do you want the wording from 2018?
I was gonna say.
So you don't like the word contribution toward?
I don't. I think that raises a red flag with banks.
The word contribution.
Well, you can just say shall pay the following expenses, and then you can say an amount to be applied to buyer's expenses, an amount not to exceed, I guess we should say. So do you still want to leave other than brokerage
you
compensation?
need something in there about do not include or other
I'd say
than.
buyer expenses, comma, which does not include brokerage compensation, comma, in an amount not to exceed blank.
Well, remember what we got here is the first part of the sentence is seller shall pay the following expenses. And then you're gonna say they're gonna pay buyer's expenses in an amount not to exceed blank dollars. Or you're just gonna say he's gonna pay an amount
John,
not to exceed blank dollars to be applied to buyer's expenses.
do you want me to read what used to be in the contract in 2018?
Sure.
Yes.
Okay. 12A1B used to say, seller shall also pay an amount not to exceed blank to be applied in the following order. Buyer's expenses, which buyer is prohibited from paying by FHA, VA, Texas Veteran Land Board, or other governmental loan program, and then to other buyer expenses as allowed by the lender.
We took out the language because we
didn't
thought
say
that,
anything about workers' compensation.
right, we added it at the same, because it wasn't in
We
the
didn't have
defined
that.
term.
Mhm.
And we discussed the caps and how those weren't hit that much, even though
I
they are.
just don't think we need the phrase other than brokerage compensation. It's
I think we still need to
We
keep
do,
that.
because there are brokers
It's
that
so
are using
important.
that.
Let's focus on
Yeah.
the language with it, because I think that's pretty strong on the boots on the ground side. I'm siding with the brokers on that one. That's big source of confusion
Yeah.
out there. But I'm with you on it not being,
Although it does say, and other expenses payable by buyer under this contract,
Mhm.
so you get circular.
mhm.
What if we just have an affirmative statement in B that says brokerage compensation and any contributions under this paragraph B are neither seller expenses nor buyer expenses?
Well, they may be.
That would confuse them.
But they just
Yeah.
took it out.
That would confuse
A1
them.
and 2, and yeah. I think it needs to be at the point of where the blank is. Otherwise, they're just gonna fill it in and expect it to be applied at the title company by wherever they think they need to apply it.
Yep.
Oh, we're so close.
Is there a problem with the way he has it now?
Let me see what he has now.
Get this for Tony.
An amount not to exceed to be applied to buyer's expenses other than brokerage.
Or
I
what if we
like
just
that.
Yeah,
add
I
a
do
couple
too.
commas, buyer expenses, comma, other than brokerage compensation, comma, in an amount not to exceed.
What legally doesn't work about the way Ron has it currently on the screen?
The phrase in an amount not to exceed, what does that phrase modify?
No, he's changed
He
it.
changed that to, it used to be at the end, and now he moved it to the
Amount not
beginning.
to exceed blank.
I think it's very clear.
So the sentence is seller shall pay the following expenses, an amount not to exceed to be applied to buyer's expenses.
I think that's clear.
Yeah.
I think that's clear.
Yeah,
Fantastic.
And
he is so good at that.
I know. Look what we
I just do,
did.
just do this and
Does there need to be anything about as allowed by lender?
I don't remember why we struck that last time. Does anybody remember?
We decided it wasn't really an issue that presented itself anymore. It was a pretty in-depth discussion we had. I'm not recalling the exact specifics, but overall it was that it was no longer needed. But
Because the lenders are going to let you know if that's
Well,
not the case,
right.
right? So I don't know, maybe they,
Somebody puts in their 20% of the contract or some ridiculous amount of money and the lender's like, no, thank you. Right.
because it was a first this, then this, then this, right?
Mhm.
Okay,
As long
be
as we're
patient
all on the
with
same
me.
page.
The only thing that happens,
Let me
I mean,
undo this.
it's
Hold on.
fine, is B is
Go to B.
not to exceed.
Check box
So
number
Brian,
two.
hold on, here, Brian. One more time, Brian.
If you check box number 2,
Mhm.
that's something the buyer will pay. correct?
Mhm.
That is therefore a buyer expense.
I see where you're going. Well, he kind of gets it back if there's a concession up here. You're right.
So
But we said other than.
So they have to pay an amount not to exceed blank to be applied to buyer expenses other than brokerage fee, compensation, or contribution.
So just flip it.
What do you mean, or contribution?
In paragraph B below.
Yeah.
You'd have to flip B. Yeah,
So it's in
A1B.
addition to,
Because you don't want to,
B.
yeah,
Oh, 12B, I'm sorry.
the amount not to exceed. Yeah, so that is an additional amount. That's a good catch.
because that was a good find, because if that could have.
Yeah.
I'm good.
Yeah. David Burton, if you don't mind muting your mic, please. Thanks, sir.
No.
Mr. Burton, do you mind muting your mic, please?
I mean, doesn't that have to get approved by the DOJ, or can the DOJ come back and say?
She's gonna have to go mute it.
They would stop it beforehand.
Somebody else.
Okay, let's see.
Oh, he's muted.
There he goes.
There he goes.
Okay. All right. I like adding more clarity there. I don't think that hurt adding that.
So the question, assuming that we're closed, I think the one question to consider is this go in all the forms, including farm and ranch?
No, because.
That, we don't have income, they love it in Farm and Ranch, so let's not
Well,
mess with what's.
And in
Yeah,
Farm
but
and
they have
Ranch,
12A in there right now.
if they don't have a separate written agreement, right? Because that specifically says the compensation is in a separate written agreement, and if they don't have one, this doesn't work for them.
Yeah.
Okay.
Thank you for saving us, Jules.
He was gonna have to bring it out on.
So that means 12A1 will stay the same as we've already put in farm and
Farm
ranch.
and Ranch,
Because farming, it's, the old one is in there. 12A1 is the old way, the way we have it right now.
Do we need to add our modified language that we were going to originally do to 12?
That's what I'm saying, but it's that language. It's not, even though they're on page 10 also, it is on 12.1.
What page is that?
I don't know.
91.
Which I have no problem with, because I don't think every contract has to have the same stuff, but we have to,
But we should be
have-
consistent.
it has to be
No,
consistent.
we were adding that. Weren't we?
Well, like we had 12AB, 12A1B, we had it in there, but they also have it at the end
No, this,
as a written agreement.
so this should go into farm and ranch
I-
and leave,
Yes,
leave,
and leave the other.
and then leave the other one.
I think so, because we'll have farm ranch transactions that have, you still need to meet the requirements of
Right.
563.
What we have there now, not this.
No,
No,
well, the new.
The new one will go in 12C. So we'll have all the new paragraph 12 in farm and ranch, just like that draft. And
Okay,
then They'll
And then
also,
we'll leave after the signature line for the separate signatures.
right.
okay.
Corey?
Yeah, the only thing I was gonna mention is since seller's expense and buyer's expense are defined in A, and then you get down to C, and it's just if any expense exceeds an amount expressly stated in this contract, so that kind of makes it seem a little broader. If it wouldn't be wise to just kind of specify if any seller's expense or buyer's expense, that's referring to just what we're talking about in A.
Well, I think it was also, there was, are there other, because you could have like in the addendum, the dollar amounts to be paid under HOA addendum, those kinds of things.
That's true.
So I think it was intended to go broader than 12.
I'm just saying that people misinterpret and misunderstand. Should there be something in that statement then, just saying, and this does not include, the broker's compensation or something like that?
Hey, that thought crossed my mind. I see where you're going with that. This is the least used and probably most why is it in there to begin with? The question that I get, and what does it apply to? And I always look at expenses people write in. Buyer will pay survey cost of X, like in special provisions, and you have an X expressly stated expense. We don't have many provisions that this actually would ever apply to in the contract itself. And now that is called out a little differently with the title and with our new changes to broker compensation, are people going to look at that and try to use it to say, hey, my compensation's more? I don't think they can legally, but is there something we can do in there to head off those potential issues now that it's a little more prominent and tied right after the broker compensation section?
That oftentimes is raised with the interest rates change. And if the interest rate goes up, does that give an out for a client? Because years and years ago, that used to be a concept that if the interest rate in the third-party financing addendum went up, that was an additional expense and therefore the buyer could terminate the contract.
And what if we
but that's
take
a
out the
third
first
party.
sentence and leave the second there? This is one where, again, I don't see it being used. I don't really see the application in our contracts too much.
Like Diane said, though, what if the buyer is going to try to use an additional fee as an out under the third-party financing addendum? And the seller says, no, I'll pay that.
But that's not an amount expressly stated in the contract. That was me.
Yeah, it's not me.
Unless the other party agrees to pay such a.
Right, but you don't ever trigger, because the if is if an expense exceeds an amount expressly stated. There's nowhere where that expense is expressly stated in the contract.
The interest rate would be.
Well,
In that
and,
example.
and now the broker compensation is expressly stated, or at least the
Well,
contribution.
that's a
they're gonna
contribution
make.
amount, which
The
doesn't,
contribution amount, yeah.
and that's where the confusion, it shouldn't be able to be used as contribution, not the actual expense. The expense is in the separate written agreement.
What's the argument why it should be taken out? Is there any harm to keeping it in?
The harm we're talking about now is the confusion that somebody might try to say, my fees are more than the contribution that's listed just above it. And so I want
I
to
have a
terminate.
buyer rep agreement for a certain amount, but I've only been successful getting the seller to pay this much. Therefore, I have the right to terminate.
Did
Wow.
it not apply to?
How do
like,
you attorneys
FHA and
interpret
VA?
that? Yeah.
That's what I always thought it applied to.
Say it again?
To like FHA and VA and those types of loans were,
Well, that's what it
Mhm.
says on the on the second paragraph.
that's what I always
Second
understood it
sentence.
to apply to.
There it says.
If I'm a seller that
Launch.
says, I will pay for this in an amount not to exceed blank dollars, and it does,
Yeah, we're 12 off.
then I can just terminate unless the buyer says, no, I'll pay the excess.
This is a revision 2.
I don't think it'll be used very often. I don't think that happens very often, but apparently it must have happened. Otherwise, this provision wouldn't have been there.
Yes, let me ask the brokers, do you think this will cause confusion being right after it's always been in there, it's not changed. Do you think it will cause confusion? And we can always tweak it if it does, later, but do you think there's something we need to do?
Or is there any other place it could go so it wouldn't raise concern and confusion? Because what Melissa said, I could just hear somebody saying, and if we can minimize, it makes sense.
I think it's fine. I think they're used to it. I think changing too much is gonna freak them out. Having closing cost and everything in one area is the where to go.
I don't know.
Where else could that be, talking about expenses? Is there a place? So it doesn't fall right after
If no one's read it
compensation.
before, it's not likely they're gonna read it.
It's before it, yeah, it's before it, and it's what they ask the lender, you know, to get their 1 point or whatever, you know, to.
Should it say if any expense in paragraph 12A above exceeds an amount? I don't know.
But it's not expressly stated then, so you would have to be writing stuff in.
Oh,
to-
right,
to do that.
Yeah, yeah.
The only problem is we're writing stuff in, that's not an expense, but a contribution right above.
You just add a statement at the very end that, you know, the contribution, I mean, you don't have to point it out even, but broker contributions are not an expense. Just like short and sweet.
Dummy proof it to.
Yeah, that might be helpful.
Well, you know, we use the phrase with respect to the contribution on buyer expenses, an amount not to exceed.
You could put that, I mean, broker compensation is not an expense if you needed to. I don't think you'd use it.
It's awkward, but if it said if any expense parentheses excluding contributions above, under parentheses, exceeds an amount expressly stated in this contract.
The only problem with that is it's not part of that expense to begin with, so it's excluding something
Yeah.
from the.
It's kind of like, how did it end up there?
It's expressed, that's what, you know.
But it's not an expense though, it's a contribution.
Right, but I mean, if they read it that way,
Doesn't
aren't you
include
expressly
compensation.
stating it? I don't see in the confusion.
I don't see how
Okay.
that could be a problem with 1 and 2. Because let's say you have 5% in there. If any expense exceeds an amount, if it's 5% that the buyer's paying, the buyer's not gonna say, oh, I wanna pay 7. And then the seller is gonna cancel the contract because,
Well, you have,
Pay more?
your buyer's rep has 10% and it only has 5% in here.
but
Then
that's
it's-
just what's in the contract.
Right.
So.
That's exactly right. It doesn't matter,
Yeah.
but is somebody going to say, oh, wait a minute, I still have to pay this amount more? It exceeds what I put in this contract. We know, but just how it be. And we may not need to do anything till it presents itself, just,
So let me be sure I understand. The concern is one party agrees to contribute an amount greater than the amount that agent,
less
that
than,
broker,
Less than.
the compensation the broker is entitled to is less than the amount of the contribution that they fill in.
the contribution's less in here, so they put 5% in here. But their agreement's 10%. And so they say, wait a minute, if this says if any of my expenses exceeds an amount stated in this contract, and it only says 5% in here, I have to pay 10. I have that determination right
Oh,
now.
I see what you're
Unless the
saying.
other party agrees to pay, so now it's forcing the seller to.
And it's not what it's
Make it
meant for.
up.
It's not
Right,
legally
right.
right, but Corey raised the point of confusion there of
Mhm.
seeing how people could read this and
Okay, is compensation considered an expense? I guess that's the
That's a
conversation.
contribution, though. Yeah.
That I don't think C would apply to that because this is just contribution of existing obligations and shall not change the party's obligations to pay compensation pursuant to those agreements.
You're 1,000% right.
Well,
It's a
also,
matter of people misreading it.
I read this to be that the expense limitation has to be stated in the contract.
Yes.
That expense limitation that you just gave is outside the contract.
Yes,
Yes,
exactly.
I'm saying, I
Yeah.
agree with y'all. It's just how others will read it,
Okay.
is what they think. And so that's the, but and this is where we may see if it's an issue or not, but something to think about now that it's a little more called out right to it and just some of the questions we've had before. And, Corey raising this, is sure you've seen it too. And some of the, we thought B and C were pretty clear at one point. And everybody's like, no, what do you mean not to exceed? What do you mean this? And so maybe we just go forward with what we have and just watch that one.
I think
we're gonna get
the responses will be wonderful.
I think we're gonna have a lot of comments.
For the record, if anybody has a question about this, at the broker lawyer committee meeting, we are saying we do not intend expense limitations to cover the broker compensation contributions in paragraph 12B.
Put it in the meeting minutes.
And
In
like
case
Ron
it's ever
said,
part of a
outside the
Yeah.
lawsuit, they can pull the history.
All this is on YouTube. You get the transcripts too.
Yep.
Okay. check the minutes. I think we
Okay, so,
fairly close to within time.
let's see, I have to pull these up.
I am impressed. It's
Yeah.
noon. I am impressed.
Thank you, John, for giving us a start.
Yes, you did.
Thank you, Ron.
It's not over yet.
Yes,
Yeah, over yet, guys.
Yeah, John, they both together.
And Ron was up sending emails at 1:30 in the morning this
Well,
morning.
you
So,
have to
yes.
qualify that. I was so tired yesterday. I went home, went to sleep at 7, woke up.
Yeah, he took a nap. We both went back and crashed, and then I didn't get up that late, but he.
I woke up and I said, where am I? Anyway, let's see here. Let me go back here to the end of these minutes here. I had, Abby, do we need to put in a notation that we broke last night in the minutes, or just that we don't have to address that and that we resume today?
You might add that.
Went to recess
Okay.
or, right there.
I'll just put it in here. So January. Okay, so
Should that say to the following day instead of date?
you are so smart, Darlene.
Well, thanks, Ron.
It's because you live in the Holy Land, by the way.
Where were you on that, Candy?
Yes, that would be correct.
Where's the Holy Land? I thought that was Austin.
That's A&M. Let's call it.
No, A&M,
We are the Holy Land.
I see.
My
Land.
parish priest referred to Ireland.
So, so that's the water notice. Then we continue our thing, and then we have paragraph 12 is shown, and then all this comes out. I'm not going to let you look at it. Get any ideas?
John, what's implementation timing on this stuff?
So this will go before the commission at the next meeting, and then it would go out for publication.
Right.
We'll come back and meet next time to go over all the comments received, and then, assuming we don't make any changes, go to the commission for final approval, and then be ready for use in June, I believe would be
Okay.
the target
That's
date.
what I was kind of wondering about June,
Mhm.
summer.
So just, I didn't put it in the minutes, but we are removing paragraph 12. I mean, I'm sorry, 8B.
Yes, we'll need to remove 8B.
Do we talk about the bottom of page 10?
We took that out last time.
Last time, okay, so we don't have to say anything now. That was in the minutes last time. So we've agreed that the changes that are in our book now are as it's gonna go forward.
Yes. With the additions of what we
Yes.
have in minutes today.
Okay, so then I think,
8B, okay.
so then we have, so now I think we just need to talk about the timing in the next meetings.
Correct.
So do we need a motion or anything to recommend?
Yes, yes.
Okay,
What do I do kind of a global one with the changes that's reflected in the minutes?
yeah,
Once we probably should go through the minutes first to make sure they,
okay,
one last time look good, then we can.
okay, let me get these. I'll just put next meeting.
We don't need to break it out, Abby, do we, for each individual?
Just one, I can point to.
And then we'll adjourn. Look, I estimated 4:18.
If everybody can look at their calendars too, just to, for our next meeting dates.
What do we have?
You already put them on there.
April
They're already
10th,
on my
there?
calendar.
Okay, April 10th,
They're already on my
there.
I
calendar.
didn't put them. What are the dates?
What do you
April
have?
10, April 10.
April 10th, it's
and
April
October
10th,
Yeah.
July 10th, and October.
They were,
July 10th.
they've been on my calendar, so I know it's
9th.
been more than one.
April 10, July
Yeah, I
10.
saw them on there, but I
And
didn't
October
say.
9.
April 10. And July, what'd you say?
July 10th. And October 9th.
April, July, October.
Okay, and then, I think that's it, so we'll go back up.
So my question is, John, okay, so this goes to Trek in February, correct?
Correct.
And then it goes out for comments. So we won't even address it till July then?
April.
April.
Oh, I lied, April.
So you'll review any public comment received at the April meeting, and then depending on if there are any tweaks, assuming not, then that could go forward at the May meeting, the May commission meeting for adoption.
Okay,
Yeah, I think the forms are dated at the top, like May 24th or something. When you go down to
So,
the forms.
Ken never, joined us, is that right?
He didn't, I
Okay,
didn't
so-
get off the same, so.
All right. And then, I didn't get all of the,
Those aren't considered attendees, they are viewing a live stream online.
okay, so you want me to remove, okay. Is it necessary to put the people who are present here or not, or just leave that off?
We have the sign-in sheet too.
So you can add those too?
Yeah.
Okay.
Historically, we have.
Yeah, I'll let you add those, Abby.
Okay.
Yeah, we usually,
Do you want to add January 8th to the top?
we sign the sign-in sheet.
where do you find
Yeah,
that?
everybody make sure they sign
Find
it.
the proposed.
There's only,
Proposed.
there's only 4 people on the sign-in sheet, and I never sign it.
No, not for committee members, it's for guests.
Oh.
You're just saying.
Yeah, you
Like,
get
wait a minute, I missed
all these
every meeting.
absences.
Yeah.
We're building a fire to kick you out one, you know, that's,
You got it.
but not that easy.
Okay, so you just want to read silently, or how do you want to do this? You
Yeah, I
want
think
to print? What's better for y'all?
How long is it? Pretty long?
There.
Look at the top.
Could we print it?
Yeah, let's probably print and then
Oh,
we can make a motion not to reprint with any changes and,
Okay.
let's maybe take a,
Oh, let me make
say,
sure.
come back into maybe we take a bathroom break, read, and then
Okay.
discuss it.
Sure.
So we'll
Let me make sure I save it.
Sounds good.
take a 10-minute break and come back at 12:28. 12:27. And we're currently reviewing
oh,
draft minutes that were printed for us to review.
Number 13 didn't have it. Just as the committee discussed.
Oh, yeah, I was going to put that in there with the, we're going to have to take a vote.
Oh, that's on the,
Yeah, so
Gotcha.
that's to come.
You're the chairman. You came first.
I know, I saw that, it's kind of similar in the notes.
So need to add that back in. Statutory. Following utility.
Everyone looking, watch what he's doing here. That was in our contract before.
Because they may have been actually been provided before.
F,
Did,
Mhm.
on that one where you just made that change, that's under the agreements to parties, right? That's paragraph 21,
22.
22, sorry. Do we need to say list all? Because that's what you have on the printed copy. Oh, list all, never mind, I see it, I see it, okay.
on, above that in C. Okay, you changed that. And then in F below, this is one, it says for purposes of performance, the effective date of the backup contract changes. The effective date's defined already in the backup contract, so do we need to capitalize?
Well, it's a quote. Oh, I see what you're saying.
Right, but-
Okay, I'm sorry. Decided to change to read. So that should be capitalized. I'm sorry.
I think it may have been that way in our forms, that's a change. Regardless.
I use small c on committee. I'm not going to look at that.
Is there supposed to be something under 13 for committee?
That's the vote.
Got you. We need to put anything about Mr. Sledge presenting.
Yeah, it's a good idea. So all I had in here, Brian Sledge. Suggested changes to the grant.
What's number 13? The committee discussed and there's no.
It's the vote we'll take here.
Hmm?
We'll take a vote here in a second. So it get filled in. We can take a motion as a vote. I know, it's a placeholder.
I'm gonna fill it in a minute.
Oh, placeholder.
Ron, I don't know
Got
if
it.
but you have, under 4, you have 2 Ds. There's a D on page 2 and a D on page 3.
Oh, that's right.
Oh, yeah.
Under 4.
Keep going now,
Yes.
so you've got a D, you'll have a D, and then keep
Oh.
scrolling, and it picks back up at D on the next page.
Oh, that was putting it in, I remember that, yeah. I didn't remember it, but I remember.
And that's 6 below that. The committee and the line up from the last line. It's missing a B.
Noted that the company form the seller's notice to remove or file removal is attached to these minutes. Just noting that.
Yeah. On which one here it is for the, I'm sorry,
It
Abby?
was under G, for G, or it doesn't change now.
There was any more edits anybody found to the minutes? One, during the issue on the potential confusion and an actual legal argument that was brought up on the expense limitation in 12C again. And before we finalize this, it's the brokers, and especially have raised concerns about how this could be attempted to be weaponized in a way that we don't intend it to. And I think this is a common concern that it's raised, but I want to, before we go forward with it, talk this one out a little bit more on 12C to see why one solution before, so we can all have a better idea of just removing the sentence about excess expenses. What purpose that served to keep it in? Because the simple solution to solve the concerns that were raised about it would be to just remove it. But if there's a reason to keep it in, then it's the step of how can we proactively change it.
I'd always thought the main reason was the second sentence. Sorry, buyer can't pay that.
If we keep
The
this,
seller could step up and say, I'll pay it.
Or if they're not willing to, then they could terminate.
tied to that, so those being read together and not having it applied to anything.
So maybe the title is not expense limitation, but it is
Loan?
loan expense
Loan
limitation or
expense, loan.
funding or FHA, VA, I don't know.
Well, remember buyer, if you go up to buyer expenses, it includes all those various things that the buyer is supposed to pay.
Right,
And we're
but
trying
I,
to prevent that from being so broad, to have not have the argument that it applies to compensation.
so what if you put under C, like what Melissa just said, loan expenses limitation or whatever, finance expense limitation. So then it's just whatever.
Yeah, can I ask one question on that before is, so if these are prohibited by VA, FHA, or the other lender,
Yes.
then if we don't have a provision that says you can pay the excess, then no one is obligated to pay it. Right?
And so the lender's not paying the loan.
Or should
Well,
it
I
be
think that's
right
why it's
there
so
in
good, yeah.
2?
So on a
Yeah.
VA, do we need something that on the VA contract that says that the seller will pay expenses that are prohibited?
That's in our,
Is that in the,
Well, we used to have a 2-tiered thing in the contract where first the amount that the seller's gonna pay would be applied to FHA and other fees that buyer is prohibited from paying, and then to others. And we said that's really not necessary, just clump them together.
so maybe we need to go back to that.
I don't know, I don't see there as being a problem. I mean, with the language we put into in bold, I thought we agreed addresses that problem because the obligation to pay is outside the contract, under the contract. under the brokerage agreements.
No, I was talking about for VA and prohibited expenses, VA and FHA.
And they don't even really prohibit it, hardly anything anymore.
No, they don't?
No.
There's very few. There's still a few, but
Okay.
it's
There's
way.
very, very,
Okay.
very small.
All right, then why don't we just take out C altogether?
I would take C out.
Or at least take out the first sentence for sure.
Does that second sentence need to be in paragraph 2, talking about buyer's expenses, where it talks about VA?
One more time.
Well, Ron had paragraph 2 up that was talking about buyer's expenses, and that last sentence, buyer may not pay fees or charges or fees expressly prohibited. Does that need to be added to the end of the paragraph that he just had up on buyer's expenses?
Well, and
I have a suggestion here, real quick. Let me throw out before it escapes my brain. If we take one out, move the second sentence to the first one, and then go into the concept by rewriting the first sentence of what we intend this to be. So seller then has the opportunity to pay those things. And if not, the parties can terminate. I have it tied to that exact thing we're trying to, instead of this broad expenses.
Do you see that much anymore?
Buyer may not pay for charges. If seller fails to pay for,
I mean, FHA doesn't have anything
pay those charges,
anymore.
either party may terminate, or fails to pay for any of those charges that are expressly stated in the contract.
Right,
Something
so,
like
I mean, the only thing I know that VA is termites, and if it's under a certain amount, because if the house is a certain amount and it's VA, they don't even ask for
that.
termites
So maybe
anymore.
not have any, just not worry about it, just have.
That's what
if we just
that's
take
the
out
only
the
one I
whole
know
paragraph.
of. If
Because
it's
maybe
under
it's
like
under the-
300 or whatever, I don't
maybe
know.
it's under the 5% rule of actual being used anymore.
Does FHA have any rules?
They don't have hardly anything in FHA.
Well,
I haven't seen, I mean, when I started, they
we
did.
don't know about all. the
20 years ago, we always had to have 1,200 or 1,300 or something in there.
What if we said, if a governmental loan program regulation prohibits buyer from paying charges or fees?
But isn't that in 2?
No, I'm just saying, if it is, then the amount of any concession in 12, what is that, 12AC,
A1B. Or it used to
A1B,
be, yeah.
what is it now? I have to check that.
Yeah.
Shall be first applied.
Well, that's how it used to be written in that one that I read up earlier, for 12A1B.
Well, we just did that and then got away from it. So then we addressed the concern about
Do you have that language still, Melissa?
I'm gonna.
Just double check, make sure we're not in quick draft and missing anything.
Yeah, no, give me just a second.
I like that wrong.
Which one are you pulling up?
Like the 2018
I'll put
contract,
that in there.
the 12A1B from a really long time ago.
Oh, okay.
Or you can say, but not brokerage compensation since it's not an expense.
So would that then go
They're not-
under buyer's expenses, since it's talking about buyers, as opposed to being at the end like that? It's kind of floating out there, possibly unnoticed.
I know years ago, I'm dating myself, is the VA did not allow the buyer to pay any brokerage fees. I don't know if that still exists or not.
No, they approved that with the new
That's
settlement.
fairly
They
recent.
approved that they could pay brokerage fees.
Most of the fees that
Okay,
aren't
I have it,
allowed
John.
more are the lenders absorbing those.
Okay.
Does
at
it
this
look
point.
what we have there?
Let's see, hang on. Well, let me read it out loud and then you can kind of look back to this. What it used to say in our old contracts back in the day was 12A1B said, seller shall also pay an amount not to exceed blank to be applied in the following order. Buyer's expenses, which buyer is prohibited from paying by FHA, VA, Texas Veteran Land Board, or other governmental loan programs, and then to other buyer expenses as allowed by the lender. That's what it used to say.
Why did that go away?
We just shortened it all when today when we were working on it, we were like,
I mean, you could put in here as allowed by the lender, so I think we were missing.
No, but you're
It's
saying
almost
they
duplicative,
pay.
though,
So is
right?
that,
Yeah, it
If we're
is.
prohibited from
To be
paying it,
12A.
then you don't have to relist it.
Right.
Yeah, I think we leave this.
so the new 12A1B would still be just buyer's expenses other than brokerage compensation in an amount not to exceed blank. And then farther down, we would have this expense limitation worded.
Right. So this would come out to.
okay, I see what you're saying.
So that takes care of that, just the VA stuff, but you have the other question of,
That addresses the question the concern we had.
well, this only applies to governmental loan programs.
Right.
That,
Oh, you removed the
That's what
first
it's always
sentence.
been.
Oh, you
The
remember
first sentence
that?
was what raised the concern about,
Okay.
I'm gonna weaponize this for the
Mhm.
compensation issue.
Right.
I like that.
I think that's a better solution because it's a lot more clear
Mhm.
and we're gonna get
Where that
less
money's
comments
going.
and pushback.
Okay. Save that. Abby, you're gonna have to remember which one is which.
Do my very best.
Okay, so with that, I think what's left on the table is making a motion to approve. Somebody make a motion?
I had a correction. Did we correct on the very top of the minutes that we had the wrong date?
Yes.
Yes.
Okay.
And I think you just need a motion to push forward the proposal.
Okay, so
And what was item 13?
That's what we're doing.
Oh, got it. Okay. Because I was like, what is that?
a motion to push forward the changes to our draft contracts as reflected in the minutes that are on our screen that we have just reviewed. And
So moved.
Second,
all in favor, say aye.
Aye.
All against it? All right. Yeah, it's possible.
Holy schmoly.
Wow.
That's a lot. I want to thank everybody. We have our meeting, next meeting's already set out here, but 2-day meetings, first one of my 8-9-year tenure on this, and everybody stuck in there, and I appreciate everybody's hard work and really caring about it. This was a really good meeting, and everybody put a lot of effort into it, so thank you all.
I think a 2-day meeting sometimes is needed because at least, I mean, otherwise this would be next October
Yeah.
that we
this
would
was
be
fine.
bringing forth.
Very timely.
Right.
Mhm.
Feels good.
So
So
I think it's awesome.
Feels like we're being progressive.
I think these are good changes that we're jumping out ahead of, especially. So the next motion and final motion we need is to approve the minutes as drafted, which we can see the new 13 that.
So I had this actually here, I had to renumber, I had a misnumbering. And just so you know, is that I had, Christie caught that we had this before the break. And so I moved it down below after the break.
Okay.
It's just a minor deal. But anyway, so you want to,
A motion to approve and probably update when at the time after we approve here about adjournment. Yes.
I move to approve the minutes.
So let it
Oh,
be
one second.
Oh.
14, the committee decided to send the current drafts to the commission. Request the forms be published for comment and adoption.
Uh,
So the current draft, is that okay? Or
It's- It would
needs to
be,
modify?
the forms would be published for, well, yeah, that's fine. That's
Do you
fine.
need something more specific or
No,
global?
that's fine.
Hooray.
You can get rid of the adoption, because it's just,
How many
it's
properties
just
do you have
application for
on my door?
comment right now.
70.
We want them to adopt it right now.
Fast track process.
When would you anticipate that they will go to the registry, the Texas Register?
So much.
To the
Oh, no,
register.
that's right. It's got to go to the commission first.
The commission, and then as they propose it, then it's
Then you need,
about 2,
so then you're not.
10 days, usually.
More employees.
Late February, probably.
The happy number, I think is.
Can I get a motion to approve the minutes?
Motion to approve the minutes?
Second.
Second.
All in favor, say aye.
Aye.
All right, it passes. And
Yeah, without.
So let's, Abby, let's say we hit all our dates.
Mhm.
When will these actually go live?
Probably beginning of June.
all right. Well, with that, we will adjourn at 12:50. Thank you, everybody.
Thank you.
Thanks. Bye.